I agree.
All rise. Monroe Circuit Court's now in session. I'm going to Judge David Williams presiding. Please bow with me for a moment of silent prayer.
Thank you. Everybody see. Please turn your mobile phones off if you have them on. So I'll remember to turn mine off. We're going to do the transported folks first. Commonwealth versus Willie Daniels. Y'all will get a list of those transported people and make sure we have them ready to go. Sentencing. Willie Daniels. Okay. This is 23 CR 0013. Mr. Daniels, were you born in 1997?
Yes, sir.
Last four digits, Social Security number 2134.
Yes, sir.
You had an opportunity to look at the pre-sentence investigation report done by probation and parole.
Yes, sir.
Is it substantially correct?
Yes, sir.
Counselor, is there any reason why this gentleman should not be sentenced today?
No, Your Honor.
On the plea of guilty, possession of controlled substance, first degree, the defendant shall receive a sentence of 3 years probated, however, 5 years supervised. Defendant shall be referred to social service clinician and follow any recommendation of clinician. Defendant shall receive credit for time served and shall obtain gainful employment or do 30 hours community service until gainful employment is obtained. And what is the court cost in this case? $240. You need some time to pay that.
Yes, sir.
Okay. Since have you got any employment lined up anywhere yet?
Yes, sir.
Okay. Well, I'll tell you what I'm going to do. I'll let you pay it $30 a month, starting 30 days from today. And that way I'll give you a little time to get back on your feet. Okay. You need to talk to the probation and parole officer. When can he meet with you?
I will be in Glasgow Monday. He can be there around 9 or 10 o'clock Monday morning. That'd be great.
Yes, sir.
Okay. Well, between now and then, live at the foot of the cross. Okay. You don't want to get started in bad start. You understand what I'm saying?
Yes, sir.
Okay. Thank you.
Thank you.
Devon Howard. We have two former members of the legislature here, and I'm a former member of the legislature, and I just acknowledge the passing of Senator Joe Wright. We all knew him. He did a lot for he did a lot for the Commonwealth of Kentucky. People don't even know what he did for this area and other areas like that. So acknowledge his passing, and I'm sure you join in that. Here's this thing. Devon Howard.
Yes, sir.
This is 23 CR 0072 and 18 CR 00173. Pretrial conference on the first case and a probation revocation. You were born in 1994.
Yes, sir.
Last four digits, Social Security number 1172.
Yes, sir.
What does the Commonwealth have in this?
There's a misdemeanor plea, Your Honor.
What's the charge here?
It's going to be fleeing or evading police second degree on foot.
Okay, well, y'all need to move to the left, so you'll need to come around. I'm having a hard time hearing you. What are you gonna do about the probation revocation? Get behind the podium so I can hear you.
I think they were just going to stipulate it, and it's just all going to be merged in with this
And
plea.
is you gonna do a revocation then?
Yes.
Okay. Okay, let me get the plea. Motion been tendered. Mr. Howard says you wish to hear your plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 23 CR 0022?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney? Are you satisfied with her advice?
Yes,
Have
sir.
you reviewed the evidence the Commonwealth has against you, and are you satisfied that you're fully informed about your case?
Yes, sir.
You understand you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights.
Yes, Your Honor.
You have the right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, the right to call witnesses in your favor and have process issued to compel their attendance.
Yes,
Your
sir.
right to appeal this matter to higher court if you lose. Your right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand that by entering guilty plea, you give up all those
Yes,
rights.
sir.
Now, I may consider the Commonwealth's recommendation, but I may sentence you to any range of sentence provided by law prior to, and this is a misdemeanor plea that I understand. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. You move to the left here.
Yes, sir.
Ms. Gordon Anderson.
Yes, Your Honor. Upon a plea of guilty to fleeing or evading police second degree on foot, the defendant shall receive a sentence of 12 months to serve. The defendant agrees to stipulate to Monroe Circuit Court case number 18 CR 173. These two sentences shall run concurrently. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the law of the Commonwealth of Kentucky.
Now, what is the sentence that is being revoked? What's probation and parole?
Let me see.
Your Honor, I believe it's misdemeanor.
Oh, no, he's probated on something else, though. He was probated. We're revoking his probation. He's entering a plea on a misdemeanor here, but what's he on probation for?
Probation is also a misdemeanor. For months on drug paraphernalia.
So what he's getting is 12 months. Okay. Is that what you agree to?
Yes, Your Honor.
Okay. Pleading guilty because you did commit the act charged in the indictment,
Yes, sir.
pleading guilty of your own free will.
Yes, sir.
Okay, well, I'll accept the plea and impose the sentence of 12 months. What are the court costs in this situation? 185. I'll let you pay that $30 a month. $30 a month, starting 30 days after your release. Is that your signature on the document?
Yes, Your Honor.
Okay, thank you very much.
Thank you, sir.
Lisa Jackson. You need this. Judgment here. Commonwealth versus Lisa Jackson, 23 CR 0025. Are you Lisa Jackson?
Yes,
Born in 1988. Last four digits of your social security number are 9624.
Yes, sir.
We're on 23 CR 0025 for pretrial conference. What does the Commonwealth have to say?
Yes, Your Honor, we've agreed to.
Hold on just a second. Y'all move to the left. Please get behind the podium there.
Yes, Your Honor, we've agreed to continue this 1 month with her co-defendants. They are all on the August docket as well.
August 17th.
Yes, sir.
Now, you're not being held on this. She's not being held on this charge on bond. It's another charge. State inmate. Okay. Okay, well, you want a pretrial, you want a negotiation day before the pretrial or?
We are currently in negotiations and we have good communication, Your Honor, so I
Okay,
think by that
so,
date.
okay, I won't set it then since she's incarcerated. Your case is continued to August the 17th, okay?
Thank you.
Do you have anything else?
Yes, Your Honor, but they are out of custody and I can
Okay.
wait for the rest of your docket. That's
Okay,
fine.
thank you. Jesus Padilla. Who's transporting Miss Jackson? Where's I have a bailiff? Somebody from the department, you were the Department of Corrections. Okay. Who is transporting Miss Jackson? I just signed the order. It's- Since she's a state prisoner, they have to have that transportation. Interpreter, raise your right hand, please. You swear that you are qualified to translate and been accepted as a translator in the courts of Commonwealth of Kentucky, and you do so faithfully.
I do, Your Honor.
Thank you very much.
Thank you.
State your name, please.
Christina Frazier.
Okay. Are you Jesus Padilla?
Yes.
You born in 1982?
Yes.
You have a social security number.
I do not.
This is 22 CR 0080, a pretrial conference. What does the Commonwealth have to say?
We have a.
Wait a second. Come around. Y'all move to, all of you move to the left. Okay, go ahead.
Misdemeanor plea, Your Honor.
Okay.
And it's up for revocation, and it's my understanding he's going to be stipulating to the revocation.
I don't have the revocation on the docket, on my docket. It's supposed to be. You check that over there.
No, it's not on the note.
What's the number of the case, the revocation? is for?
It would be 21 CR 69, 21 CR 68, and 21 CR 11.
What are the sentences on those? You gonna run this?
They're all going to be, let's see here, I think concurrently. Yes, they're all going to run concurrently.
Well, they have, the misdemeanor would have to run concurrent with them, but I wonder what they are. What are those sentences?
I'm not for sure, Your Honor. One sec.
There's 3 revocation sentences.
He has a 5-year.
How much time is he gonna get? Okay. Okay. Bring him back around here. A motion has been tendered, sir, that says you wish to enter guilty plea. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictment 22 CR 0080?
Yes.
Have you discussed this matter with your attorney?
Yes.
Are you satisfied with her advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you?
Yes.
Are you fully informed about your case?
Yes.
You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know you understand those rights. You have the right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury. You have a right to be represented by counsel at your jury trial. You have the right to confront and cross-examine all witnesses. You have the right to produce evidence, to call witnesses in your favor, and have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose. You have a right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charges against you. You understand by entering a guilty plea today, you give up those rights.
Yes.
I may consider Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. This is a misdemeanor plea,
Yes, Your Honor.
so I don't have to have a pre-sentence investigation report. However, in the event that I do not accept the Commonwealth's recommendation, you have a right to withdraw your plea of guilty and proceed to trial. You move to the left here. Yeah, I'll move to the left also.
I thought you wanted
Okay, all of, yeah.
Upon a plea of guilty to theft by unlawful taking or disposition over $500, but under $1,000, the defendant shall receive a sentence of 12 months to serve. The defendant stipulates revocation on Monroe indictment number 21 CR 69, 21 CR 68, and 21 CR 117. This 12-month sentence shall run concurrently with Monroe indictment number 21 CR 69, 21 CR 68, and 21 CR 117. The defendant shall have no contact with the victims. The defendant shall pay restitution in the amount of $900 to the Monroe Circuit Clerk's Office within 60 days of being released from incarceration. It shall be dispersed in accordance with said forfeiture order. Restitution is subject to a 5% clerk's fee. The defendant agrees to have any and all evidence destroyed in a manner consistent with the laws of the Commonwealth and the holding agency.
Is this what you agreed to, sir?
Yes.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
El delito en el cual está acusado. Se declara culpable porque cometió ese delito. Yes.
You plead guilty of your own free will.
Culpable por su propia voluntad. Yes.
Is that your signature on the offer?
Yes.
Okay, and the offer has been gone over with you in your own language,
Yes.
first language, I should say.
Yes.
Okay. I'll accept the agreement, the restitution order of 900, but in addition to that, the cost, court costs are, in this case, how much? What? You have DUIs or something? You what? What kind of case was that? It's out of. And were those fines probated? Yes, considerable. Have you looked at the fines he has collectively on all these?
Your Honor, I'm not sure. Is that out of district court?
No, it was on the pleas here. On these probate, evidently these probated cases, there were some pleas, I don't know, but it's,
Under 21 CR 117, he had a failure to maintain insurance second offense, so that's $1,000.
so that was already out there and evidently he hadn't been paying it then.
We weren't aware of that, Your Honor.
I mean, but you know, it kind of brought to my attention when this large amount of fines were going up, where are the fines, you know, and the fines hadn't been probated, you know?
Was that a circuit court case?
I can't hear you.
That was under 21 CR 68.
That was a 68, no insurance, 21 CR 00068. I don't know why he hadn't been paying it up to this point. You see what I'm saying? It was 60 and 69. Well, my point to defense counsel and the prosecution is he hadn't been paying these fines. What chance you think there's going to be for him to pay the restitution?
I'd say slim and none, Judge. It's not his nature to do that to begin with.
Yeah. I'm not going to accept this plea.
Your Honor, if I could explain the plea, I did a lot of work on this case. There's no question that this gentleman stole some catalytic converters from Mr. Gove down in the south end of the county. The Commonwealth was unable to prove the value. And that's the reason we're taking a misdemeanor plea. That's simple.
Okay, well, under those circumstances, in the statement, I'll accept, what are the total court costs? $1,605 are court costs and fines from these previous cases, plus $900. I'm going to say $100 a month, starting 30 days after release.
Sorry.
That's good.
Preferably, the money will not come from stolen property.
Solo que me dejen trabajar y yo lo pago.
As long as I can work, I can pay for it.
Okay. Well, there's one thing for certain around here, there are not people lined up to try to work. So there's plenty of work to do. Make sure the dates on these orders and they're correct. There are a lot of orders in there. Okay, thank you very much.
Thank you.
Edward Schultz. Edward Schultz.
We have a case.
Have Marlon Stout on deck, okay? Edward Schultz, come around here, please. Commonwealth Kentucky versus Edward Schultz, 23 CR 007. Are you Edward Schultz?
Yes,
Were you born in 1995?
no,
What year were you born?
1979,
What are the last four digits of your social security number?
3701.
None of this is I got on here is right. 3701, okay. You have an attorney?
Yes,
Who's your attorney?
Tracy Shipley.
Public advocacy?
Your Honor, this is an appeal case.
It's what?
This is an appeal case for private attorneys handling.
What's this thing? Where is your attorney? She's from Louisville, is that right?
Tracy Shipley.
Yeah, she's from Louisville or somewhere. I think I was reading that. She not here?
I don't know.
Yeah, I've got it here. She's with Larry Foreman, Foreman and Associates.
Yes.
I read this last night. Well, just go back there and we'll call you back out when she comes. Could, I don't know why she's not here, so. Marlon Stout. Commonwealth versus Marlon Stout. This is 23 CR 007. Are you Marvin Stout?
Yes, sir.
What's your year of birth?
32695
The last four digits, social security number.
8009.
Okay, you're here for a pretrial conference. What do you have here?
Your Honor, I was going to ask if we could continue this case for another pretrial and negotiation date. There are some videos, discovery videos, that we are still working with the Commonwealth to make those accessible so that we can.
Does Commonwealth agree with that?
No, Your Honor, we're ready for the trial.
Okay.
Your Honor, I would oppose setting a trial
Well,
date at this time.
Well, tell me exactly what it is. There's discovery that you don't have.
Your Honor, there are some security videos that the Commonwealth alleges implicate Mr. Stout in this case. We are unable to view those. It appears that the files that we have received are corrupted. We've been working with COT, and I've also spoken with the Commonwealth about being able to get accessible copies of that for review. I don't feel as if we can adequately even begin to prepare for trial without reviewing all of the discovery in the case.
Okay, I'll move over this way.
Your Honor, we were just made aware of that this morning. They didn't have the videos.
Well, he's in jail. So when's the negotiation day this coming month?
I believe August the 4th.
Okay, you have your client there August the 4th. And August the 17th is his next court date, and we will set a trial date unless in time for the Commonwealth to respond, you file a motion in particularity about what efforts you've done to review those tapes. Have y'all had any, is Commonwealth had any trouble viewing the tapes? Have you looked at the tapes?
Yeah.
You haven't had any trouble looking at the tapes?
No, it's our program, I think, that we upload them into for them to get.
Okay, will you work with them to see if you can get it where they can use it? Okay, thank you very much.
Your Honor, there is one final thing. Mr. Stout has made me aware that he has secured a bed date, I believe at Hope Haven for the 11th.
You'll need to talk to Commonwealth about that.
Yes, Your
Okay.
Honor.
Melinda Webb. Melinda Webb. Is this a companion case with Tommy Webb?
No, Your Honor,
Okay.
it just happened to have the same last name.
You make sure they have Tommy Webb on deck over there too. Yeah. Commonwealth versus Melinda Webb, 22 CR 0068 for probation revocation and 23 CR 0032 for a pretrial conference. Are you Melinda Webb,
Yes, sir.
born in 1977?
Yes, sir.
Last four digits, social security number 0010.
Yes, sir.
What does the Commonwealth have to say in this case?
Your Honor, this thing is here today on two issues, really. Mainly, it's here, it should be here today on Commonwealth's motions to revoke.
Well, you have the pretrial conference on
And then
23.
we have a
So
pretrial conference on another case.
do you have any resolution on the other case?
We don't have a resolution. I think we could. Frankly, we don't know what to do with Ms. Webb, Your Honor. We've reached the point that nothing works. And we have no choice but to move for a revocation and a trial date. That's
Okay.
all that's left.
Mr. Stockton had a conversation.
Will you kind of move around behind it and get right down on the right? Wait just a second. I can't hear her because. she
Mr.
got a-
Stockton and I had a conversation about this case Tuesday. He has given me an offer and asked me to talk to my client about that. We had discussed putting this on to the next settlement conference date. We're also waiting on the labs. This happened at the end of April, so we're not confident the labs have finished testing yet, just because it's not been so long.
But she's
So
gonna be incarcerated. So
she's being held. We're not asking for any change in bond or any
that's
circumstances.
fortunate. August the 2nd negotiation. You know anything about the labs, whether their labs are out or not?
I think Jesse was checking on that.
I'm asking if they know anything about it.
No, Your Honor.
Okay. Well, August the 2nd, obviously, if the labs aren't out and their labs that are relevant, we'll just have to wait till they get here. And then August the 17th, next court date, August the 2nd for the negotiation. Tommy Webb the 3rd.
Your Honor, the paperwork didn't get signed or something, so they would let him come to
They wouldn't what?
the transport orders didn't get signed. So they didn't.
Where is he?
In the Barron County Jail.
I'd say we just need to bring him over here.
Well, you all represent him. Give me a minute to speak with.
Okay, you'll have more than a minute. Go ahead out there all the time you want. We have a Cumberland County case, Nicholas Sexton. Nicholas Sexton here.
He is, Your Honor.
This Cumberland Circuit Court shall come to order in special session in Tompkinsville by agreement of the parties. Commonwealth versus Nicholas Sexton, Cumberland Circuit Court action number 23 CR 0019. Get behind, let him on this side, you get on this other side of him. Okay. Are you Nicholas Sexton?
Yes, sir.
Born in 1999?
Yes, sir.
Last four digits, social security number 4687.
Yes, sir.
What was the Commonwealth have in this case?
Your Honor, we are needing another negotiation day. We're having some trouble uploading some videos. I think they're needing to review. So we just need to set it for the Cumberland County negotiation day,
What day is that?
August the 18th.
August the 18th. And then what's next rule day in Cumberland County?
August the 31st.
31st, 18th for negotiation and the 31st for your next pretrial.
Yes, sir.
Anything else?
No, Your Honor.
Okay, thank you very much.
Thank
Okay, we're going to start down to the out of custody. Paige Adwell. Paige Adwell. 23 CR 009. Are you Paige Adwell?
Yes, sir.
Born in 1985.
Yes.
Last four digits of your social security number, 3041.
Yes.
We're here for a pretrial conference. What does the Commonwealth have to say?
Your Honor, this is going to be deferred prosecution. I think there's an application for it as well as an order that we tendered on it. And the reason Mr. Stockton has given for it is that Ms. Adwell, she has a good job with Dollar General. She was investigated for theft, but they only found a small amount of meth. And the officer that investigated this, he hasn't worked for the sheriff's office in a long time. So that's why Mr. Stockton was agreeable to this.
Another pretrial diversion. You got paperwork on this?
Yes, sir.
Let me see the paperwork. We haven't done one of these in 10 years or so.
Got an AOC form now, Judge.
Well, yeah. Do we have a deferred prosecution program?
I guess we do now, Your Honor.
Yeah. I'm not aware of it. Who runs it?
It's fairly new.
Yeah.
In all honesty, Judge, yesterday was my first knowledge that a form like that existed.
Okay, Mr. Bell, I'm gonna go see if it's got any.
Been printing them out, Judge.
I'm really not prepared to accept this today. I'm not really familiar with us ever having done this before. I don't know what the requirements of it. Not required to accept any responsibility or do an Alfred plea. What if she violates the deferred prosecution? What happens then?
My understanding, they can bring the case back, start back where we were at negotiations.
I guess it would be just like the old laying it on the shelf for an indefinite period of time, Judge, at the discretion.
Or just continuing it.
Yeah.
It is permissible under the statute, Judge, which may not, or may matter to you, may not, but
I try to follow the statutes when I'm so inclined.
Oh.
218A.1415. Well, I'll take this under advisement and set her back on the docket for August 17th. We'll make a copy of this here and take it with us, okay? Okay, thank you very much.
thank you, Judge. Judge, I had one that's supposed to be here in custody.
Who's that?
Gary Hall, on for an arraignment. We had.
Did you send a
All right.
transportation order?
I'll be honest with you, I don't know. We usually don't do that. I thought they usually done by.
We always do that. There has to be a transportation order.
I thought it was here on a motion for bond reduction.
It was on for arraignment. We put the motion for bond reduction on at the same time.
Oh, okay.
Well, I guess we'll have Gary Hall.
Yes, sir.
He's on the Zoom docket.
Okay, thank you.
Stephen Bray. Stephen Bray. He's out of custody, he's supposed to be.
The last time he was supposed to be here, there was from some certain more because he was in some type of rehab.
Is he back there now?
I don't know if he don't look.
But you got one case,
Yes,
Commonwealth versus Rondell Phelps.
yes.
We're here to schedule a negotiation day.
Wait till he gets up here.
Oh, okay.
Commonwealth versus Rondell Phelps, 23 CR 0021. Are you Rondell Phelps?
Yes, sir.
Born in 1945.
Yes, sir.
Last four digits, social security number 5564.
Yes, sir.
What does the Commonwealth have to say on this case? Y'all will move to the left here a little bit.
And we need a negotiation day,
What date will it be on? August the
August
second?
the 4th.
Thought you said August the second previously.
August 4th.
You set one for August the second, just a
Set
little
one for
while ago,
August the
so
2nd.
that. I had that problem in this case. Supposed to be here the 7th. I came and they had the day on the 6th.
Didn't somebody just tell me August the second a few minutes ago?
You did.
Okay, well, I said the second, so we need to get a hold of that other defendant. Because I wrote the second down here. August the 4th. And then the next is August the 17th, the next court date. Okay?
Thank you, Your Honor.
Yeah,
Thank you.
yeah. Okay. Well, Mr. Bray is out of custody and y'all don't know where he is. Check and see if the summons was served on him, okay, on Mr. Bray. You know what? Summons was not served. I guess that we need to issue.
I didn't last month, Your Honor. I don't think he's been arraigned.
The summons was not served. Instead of a warrant, we issued a summons because he was in a rehab and they have not served it. So now we'll issue a warrant. Many times, the local constabulary don't feel compelled to serve a summons like they do a warrant. So now we'll issue a warrant. Addison Bryant. Monroe versus Addison Bryant, 23 CR 0035. Are you Addison Bryant? Were you born in 2004? Last four digits of social security number 8190.
Yes, sir.
Represented by Mr. Garrett. We're here on a pretrial conference. Y'all move to the left a little bit. What does the Commonwealth have to say?
We have a pretrial diversion, Your Honor, for this case.
Okay. Get behind the microphone now. Mr. Bryan, a motion's been tendered, says that you wish to enter a plea today. Is that correct? You wish to enter a plea today? Can you not hear?
He can't hear, he can't judge.
Okay, well, do you have a hearing aid in?
Yeah, I have one.
Okay. Well, we can't use these microphones unless he takes it.
We stand closer to the bench.
A motion has been tendered that says you wish to enter a plea. Is that correct?
Sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in 23 CR 0035?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed these charges with your attorney?
Yes, sir.
Are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? You believe you're fully informed about the case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea of guilty, I need to know that you fully understand these rights.
Yes, sir.
You have the right not to testify against yourself. No one can make you say anything. Your right to speedy trial by jury, the right to be represented by counsel at your jury trial.
Yes,
The right to confront and cross-examine all witnesses called to testify against you, to produce evidence, to call witnesses in your favor, to appeal this matter to higher court if you lose. You have a right to Commonwealth to prove beyond a reasonable doubt that you're guilty of charges. You understand by entering a guilty plea today, you give up those rights.
Yes, sir.
You realize that I do not have to accept the recommendation. If I do not accept the recommendation and decide to impose harsher punishment, you'll have the right to withdraw your plea. Have you previously been diverted in the last 5 years?
No, sir.
Do you have any felony convictions in the last 10 years?
No, sir.
Are you on probation now?
No, sir.
You understand if you are admitted to a diversion program, the charges and successfully completed, the charges will be dismissed. You understand that?
Yes, sir.
You understand that if you do not successfully complete the diversion program and you're brought back before me, we will order a pre-sentence investigation report and schedule a sentencing. You understand that?
Yes, sir.
What is the Commonwealth's recommendation? Y'all move to the left, please.
Upon a plea of guilty to wanton endangerment, first degree, 2 counts, the defendant shall receive.
Wait just a second.
Sorry.
You need to pay attention to this, okay? Go ahead.
Upon a plea of guilty to wanton endangerment, first degree, 2 counts, the defendant shall receive a sentence of 1 year on each charge to run concurrently for a total of 1 year, pretrial diverted for 1 year. The diversion is to be supervised. The defendant agrees to have no contact with John C. Wilson. The defendant shall either obtain gainful employment or do a minimum of 30 hours per week of community service until gainful employment is obtained.
Is this the firearms case that he come over and discharged a firearm?
Yes, Your Honor.
I'm not gonna accept this plea. Unless somebody gives me a reason for it. Somebody comes over here and discharges a firearm.
Your Honor, it's my understanding that the victim in this, John C. Wilson, he did not want to go forward with it.
I don't care
Yeah,
whether he
and-
wants to go forward with it or not.
And the girl that was, I think the reason as that caused all this, she's now pregnant with the defendant's baby at this time. And so that's kind of the situation now.
No, there's I wouldn't say anything about him firing shots. It'd be too easy, so. This just does not seem right to me. So. Y'all come up and explain to me what happened again. I just remember a little bit from the arraignment.
I believe that Mr. Bryant, he came to Monroe County. He was at Walmart parking lot, discharged his firearm in the direction of where Mr. Wilson and the female were in a truck. And that's where the 2 counts of wanton endangerment come from, was where he fired the shots towards them.
I'm not going to accept this plea, so let's schedule a trial.
We do a negotiation day, Judge.
Do what?
Negotiation day,
Yeah,
see if we can resolve this.
August the 4th. And the next court date is August 17th. I want to, and just about some explanation, not that I really have to give one. There are a couple of things that really bother me. One of them is when someone's out on a bond, which he wasn't, and they're driving under the influence without insurance and that sort of thing, or a convicted felon with a firearm, or someone coming over and discharging a weapon in the direction of someone. And the reason is because the people on the other end of the discharge of the weapon, it's not like you're firing a warning shot across their bow. Those other people have a weapon and they have a right to. We have a gunfight in a Walmart parking lot. So that has to be discouraged. So y'all negotiate it. Okay. Say on the same line, Jenna Ford. Jenna Ford. You know where Jenna Ford is?
Walking up, Your Honor.
I'm over versus Jenna Ford, 22 CR 0088. Are you Jenna Ford? Were you born in 1995? Last 4 digits, social security number is 7835.
Yes, sir.
We're here for a pretrial conference. What does the Commonwealth have to say? Y'all move over that way.
We have a pretrial diversion plea.
Okay. Mr. Ford, a motion has been tendered, says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Well, I mean,
Yes, sir.
okay, are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in 22 CR 0088?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed these matters with your attorney? Are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you and you believe you're fully informed about the case?
Yes, sir.
You understand you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have right not to testify against yourself. No one can make you say anything. Your right to speed trial by jury, your right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charge against you. Understand by entering a guilty plea today, you give up those charges, those rights. You understand that?
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. And if I do not accept the recommendation, you can withdraw your plea and proceed to trial. You understand that?
Yes, sir.
Have you previously been diverted in the last 5 years?
No,
Do you have
sir.
any felonies in the past 10 years?
No,
Are
sir.
you currently on probation?
No,
Do
sir.
you understand that if you fully complete the diversion, the charges will be dismissed? You understand that? You understand that you do not have to fully, if you do not fully complete the diversion, you'll be brought back in court, a pre-sentence investigation report will be done, and you'll be sentenced to be a convicted felon. You understand that?
Yes, sir.
That could enhance penalties in the future. You understand that? If you have other felony convictions. You understand that?
Yes, sir.
Okay. Move to the left here. What is the Commonwealth's recommendation?
Upon a plea of assault third degree, the defendant shall receive a sentence of 5 years, pretrial diverted for 5 years, supervised. The defendant is currently seeking treatment at the Recovery Plus for Women. She shall continue and complete the treatment at the Recovery Plus for Women. She shall follow all the recommendations of her mental health providers. Probation and parole shall monitor and report any problems with her mental health treatment to the Commonwealth. The defendant shall maintain gainful employment, and she shall receive credit for any time served. She shall remain active supervision until all restitution, if applicable, fines, court costs are paid in full, or further orders of the court.
Now, what if she leaves the treatment center?
That too would be a violation.
Because that's not in the agreement.
Should be, I would say probation.
Your Honor,
and parole.
it says that one of the conditions is that she continue and complete treatment at Recovery Plus for Women. So that would be a condition of the pretrial diversion.
What if she doesn't complete? That's what I'm saying. She should report. Let's say she decides to walk out. What happens? We have to file a motion to revoke her. Is that what you do? Is that the way you want to do it? Okay. Are you pleading? Is this what you agreed to?
Yes, sir.
Okay. Is anyone, are you pleading guilty because you are guilty? The acts charged in the indictment is amended.
Yes, sir.
Are you doing so of your own free will?
Yes, sir.
Is it, knowing your constitutional rights, are you saying that you agree to let the court fix your punishment?
Yes, sir.
Okay. Is that your signature on the docket?
Yes, sir.
I'll accept the agreement and diversion. And did you have somebody transport you here from this place today, or how's she getting here?
Your Honor, she is in the final phase of treatment. She is able to drive and to leave for court dates and work at this point. So I believe she transported herself.
So she's completed her treatment there.
She is in the final phase, Your Honor, which is like sober living.
So in other words, she's not having to do anything. She's already completed this treatment.
I still have a few months left, and I go back up to treatment team to see if I'm eligible to graduate and complete the program.
So you're at home now?
No, it's in September. I'm not at home. I'm still in the program. It's just there's different phases to
Where
it.
do you live now?
Madisonville, Kentucky.
Yeah, that's okay then. All right. You want to sign it? Oh. Sure, I've signed it. Okay. She need to talk to probation pro over there. Miles Gerald's. Commonwealth versus Miles Gerald's. 22 CR 00060. Are you Miles Gerald's?
Yes, sir.
Born in 1994.
Yes, sir.
Last four digits, social security number 7078.
Yes, sir.
Okay. We're here at the Pre-trial conference, y'all move to the left a little bit here. What's Commonwealth have to say? Would you come over here?
This matter has been delayed. This is the case where Mr. Bell has raised the issue of the legitimacy of the road stop. It has been briefed by Mr. Bell and the Commonwealth.
We got that yesterday. I would ask the court if I would allow us one more negotiation day.
But,
You must have won, Mr. Hunley.
well, it's good to hear.
Yeah, it's always good.
How, but he did.
Yeah. Cheated death again, right? Okay. August the 4th for negotiation day, and the next court appearance is August 17th.
Be free to go, Judge.
As far as I'm concerned, I guess.
Nobody ever informed us.
Both of those dates are a condition of your bond. You understand that? Mary Gerald, there's the active warrant, Mary Gerald. Does anybody know anything about that? Is anybody, y'all gonna put her in NCIC, Mary Gerald, or what the deal is? Active warrant, she has not been served.
Is she in?
Nicholas Highland, active warrant, Nicholas Highland.
He had something last night, so he'll be on the way.
Okay. Dustin Jesse.
Oh,
Commonwealth versus Dustin Jesse, 23 CR 0010. Are you Dustin Jesse?
Yes,
You
sir.
born in 1991.
Yes, sir.
Last four digits, your social security number are 0707.
Yes, sir.
We're here on 23 CR 0010 for a pretrial conference. What does the Commonwealth have to say?
Need a trial date, but I believe he's a co-defendant with Mr. Stout, who we tried to set a trial date earlier, and there was a problem with the video. So I'm not for sure if Mr. Garrett's having the same issue.
I've seen the video.
Okay.
Doesn't change your mind about entering a plea, does it? Not really.
It does not.
Okay. August 4th for negotiation, since the co-defendant will be there that day. August the 4th, and then the next trial, we'll set a trial date on August the 17th when you're back here. Now, make sure that might have been the defendant I gave the wrong date to. Okay, see you then. Sean Jones, active warrant. Sean Jones, active warrant. NCIC. Bonnie and Tommy McClendon. Bonnie and Tommy McClendon. Bonnie, are you Bonnie McClendon?
Yes, sir.
You were born in 1956, so.
Yeah.
Last four digits, your social security number, what?
5040.
Okay, this is 23 CR 0029. Mr. McClendon, you were born in 1952.
Yes, sir.
Last four, what are the last four digits?
0552.
This is 23 CR 0028. What does the Commonwealth have in this?
Yes, Your Honor. We have reached agreement to a resolution of pretrial diversion in this case.
Okay,
The first case, Your Honor, would be 23 CR 028. That's Mr. Tommy McClendon. This
well, I'll
is-
just go over the pretrial diversion checklist with both of them. If they have similar, then you can announce it. Okay. And this would be for 23 CR 0029 for Bonnie McClendon and 23 CR 0028 for Tommy McClendon. I want both of you to listen to this if you can. A motion's been tendered that says you wish to enter a guilty plea today. Is that correct? That's what a pretrial, a diversion is.
Yes.
And I'll explain down through here. Are you
Yes, sir.
currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you both the same people that were mentioned in the indictment? 23 CR 0029 and 23 CR 0028. Have you discussed this matter with your attorney?
Yes,
Are
sir.
you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you, and are you fully informed about the case? You understand you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea of guilty, I need to know that you fully understand those rights. You have the right not to testify against yourself. No one can make you say anything. Your right to speed trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of charges against you. You understand by entering guilty plea that you give up those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Now, have either one of you been previously diverted in the last 5 years? Have you had any felony convictions in the last 10 years? Are either one of you on probation? You understand that if you successfully complete the diversion agreement, the charges will be dismissed, pretrial diverted, and you can get your records expunged.
Yes,
You understand that? You understand if you do not fully complete the program, you can be brought back in front of the court, and should the court find that you have violated the terms of the pretrial diversion, a pre-sentence investigation of what will be done, and you would be convicted felons and could be sentenced. You understand that? Step to the left, please, both of you. Mr. General, will you go ahead and say what the recommendation is?
Yes, sir. On 23 CR 028, which is Mr. Tommy McClendon, Your Honor, this is the case where we previously discussed the counts are a little bit normal indictment. In this case, Your Honor, it counts 32, 33, 34, and 35 are all the identical charge of making, receiving expenditure for a vote. Those all would be given a 1-year recommendation. However, they would run concurrent to one another through 32 through 35 for a total of 5 years diverted. The conditions on that, Your Honor, would be at some point.
Well, here's the situation. Are there certain conditions that you don't want entered into the record that will speak for themselves? Come up here for a second. Defendants can come up here. One juncture, I thought I was informed that y'all want to do this outside in case they agreed to testify truthfully, and you didn't want them to say that publicly because we broadcast.
Correct.
That's what I'm referring to.
So all I was going to say, Your Honor, is that they provide a statement at some point to the Commonwealth.
I don't think you need to say that.
Okay.
As a matter of fact, I don't want to do anything that would endanger them or anything.
Right.
I don't think I take any kind of recognition. So you just say that they'll comply with the terms of the agreement. I'll tell them that they're in there, and I think they'll seal the $3 version. So after this is over. Okay. Thank you very much. Okay.
So, Your Honor, it would just be that they comply with all the conditions to this plea.
Okay. Now, is that what you agreed to, Mr. Clinton?
Yes, sir.
Okay. And you did, but you entered this plea because you are guilty of what you pled to and for no other reason. Is that correct? Knowing your constitutional rights are explained, is it still your desire to give up the rights and enter this plea and allow the court to fix your punishment? Is that your signature on the agreement?
Yes.
Okay. I'll accept the agreement and diversion. Now let's go to Mrs. McClendon.
Yes, Your Honor. This is counts 30, 31, and 37 of the indictment. Counts 30, 31, and 37 would be given the same recommendation, Your Honor. One year running concurrent to one another for a total of 5 years of diversion. And then the only other thing, Your Honor, like we previously spoke to, is that they'd comply with the conditions that we've laid out.
Ms. McClendon, you want to come over? Is this what you agreed to?
Yes, sir.
Okay. Are you entering a guilty plea because of that you are guilty of the acts charged in the indictment as amended?
Yes, sir.
Okay. Knowing your constitutional rights, it's still your desire to go forward and allow the court to fix your punishment within the range permitted by law. Is that your signature on the document?
Yes, sir.
Okay, I will accept and sign the diversion agreements, and at least for the time being, by agreement of the parties, the diversion agreements will be sealed. Is that correct?
Fine, yes, Your Honor.
Okay. Okay, we all need to go over and talk to the probation and parole officer. There's no supervision or anything. You'll get information from, okay? Where are the diversion agreements?
Your Honor, all we were asked to sign is what we have there, and we discussed. I don't know if there's additional forms you need.
Well, I think there will be.
It's usually an order granting.
Yeah, I don't have an order. I say I don't have it here. And so what you'll need to do is just get one of the forms. Commonwealth Attorney can provide you one of those forms, okay? And then you'll get those, and then if it's all right with the Commonwealth, we will be required to sign that as their recommendation. I'll seal these, and we'll seal those others also. Y'all have a blank form or those normal pretrial diversion agreements, or can you make one for them? They'll cooperate. Be all right for the local Commonwealth Attorney to help you with that. Maybe you can do that before you leave here today, and that way you can sign it, okay? Seal these one in each file, okay?
Jane, can you make me copies before you do?
Alexis McQueen, active warrant out, Alexis McQueen. Y'all gonna make sure you take a look at NCIC. Okay. Jesus Padilla, the junior. Okay, this Jesus G. Padilla. Are you Jesus G. Padilla? You born in 2002? You don't have a social security number? Okay, it's 22 CR 00105 for pretrial conference. What does the Commonwealth have to say?
We're ready to set a trial date.
What is the charge here? And have y'all negotiated this?
Yes.
Okay. Where is she?
She's here.
Maria Rivera. Maria Rivera.
We're gonna be using a Spanish translator. I have a Spanish translator that we've been using for our negotiation day. And she just asked that I try to get 2 or 3 dates and give her at least, I think she said at least a month for them to work with their calendars, for her to be able to be here for a trial.
Are you Maria Rivera?
Yes.
Born in 1986?
Yes.
You do not have a social security number?
No.
Okay. Okay, let's see what we got. The Clinton County case, Commonwealth versus Phillips. Do you know where that, y'all wouldn't know anything about that, would you? Going, okay. Commonwealth versus Thrasher that's set up for 21 through the 23rd. Pardon? They're not, they're special prosecutors on that case. Commonwealth versus Foster in Clinton County. What is that case? A murder case? Murder?
I guess so.
Is there a death involved in it?
There was a shooting. She shot in the apartment. In the apartment.
Who was that?
Sydney Foster.
Yeah. We're not prosecuting.
Yes, they are.
What about August the 30th?
I have that available, Your Honor.
August 30th. Okay, well, any pretrial motions would need to be filed on August 17th.
Yes, Your Honor.
Okay. And far enough in advance for the Commonwealth to have an opportunity to respond. Okay, thank you.
Thank you, Your Honor.
Travis Pike, active warrant. NCIC. Michael Reed. Did you have Travis Pike?
Oh, sorry.
Okay. Be careful getting up, moving around, you get called on. Commonwealth versus Michael Reed, 22 CR 0090. Are you Michael Reed?
Yes, sir.
Born in 1982?
Yes, sir.
Last four digits, social security number 5155.
Yes, sir.
Okay, we're here today on a pretrial conference. You know, move to the left here, your other left.
I believe that he has a co-defendant with Andrea Stinson. They may be trying to get some type of funding to get an expert. That's what we were waiting on.
Where is she?
She is here, Your Honor. Her case was actually continued by agreement with Mr. Stockton, but it was still on the docket, so she is present.
Okay, why don't you bring her up here? Let's, what's the charge here? Yeah. You have an ex parte motion still pending?
Your Honor, there was one pending. We do plan to have another expert for the court to consider the next court date.
Okay. Well, it'd be good to do it before then. We can go on the record somewhere else. Negotiation day, August the 4th. And
I've got a trial scheduled for August 17th. I know that was the next rule day.
we'll go to the negotiation day. And then the only thing we'll be doing on the next date is setting a trial date. And we can do that with you without you being here if you want to.
Okay.
Unless you have some motions. I mean, it's not, we're not going to have a trial before the 17th.
With your permission, I can not be here on 17th, then, Your Honor.
Well, or you might be here. Your trial might be continued. Right now, you've told me that you have a conflict, okay? So what you need to do is when it gets closer to time, just give notice to the Commonwealth of how you want to establish a trial date. We might be able to patch you in briefly by phone from somewhere else. with your client being here and the counsel for the co-defendant. We can work around it.
Thank you.
Okay. Okay, thank you. Jonathan Russell. Jonathan Russell. Commonwealth versus Jonathan Russell. 23 CR 0012. Are you Jonathan Russell?
Yes, sir.
Were you born in 1978?
Yes, sir.
Last four digits, social security number 7142.
Yes, sir.
We're here for pretrial conference. Y'all move to your left a little bit. What does the Commonwealth have to say?
I believe we just need another negotiation day.
August the 4th and then August the 17th. Both of them are conditionally bond.
I filed a motion to dismiss under the Castle doctrine, Judge Swan. We believe it.
Yeah, the 17th.
17th.
Make sure, notice it for that date, 17th.
I filed it,
Probably yesterday or last night about midnight.
I think last week.
Oh, okay.
To be quite honest with you, Judge, I don't keep up with none of that, so I have no idea.
Well, he's entitled to a hearing on that, so, okay, thank you. Make sure you might want to send the prosecution a copy of it too. I know it's not always done. Okay,
Mr. Stockton, we talked about. it
Cindy Smith.
prior.
We've been discussing that for some time.
Cindy Smith.
Flashlights on your phone.
Are you Cindy Smith? Yes. Were you born in 1974? Last four digits, social security number 6098. Yes. Your day on 20 CR 0013 and 21 CR 0018. For pretrial conference, y'all move to the left. So what does the Commonwealth have to say?
We have a plea, Your Honor, believed to be a felony plea.
Okay,
Yes.
Ms. Smith, you can come back around here. Motion's been tendered, says you wish to enter a plea today. Is that correct? Are you currently under the influence of drugs or alcohol?
No.
Is this plea? Y'all are picking up on the microphone over there, guys.
Sorry.
You act like you're in Barron Circuit Court here. Okay. Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Is this plea freely and voluntarily given? What'd she say?
No, sir.
No, sir. Okay, let's set a trial date.
No, let's see what you said.
Okay, what, you got your calendar over there?
Yes, sir. I didn't understand what you meant.
Are you the same person named in these two indictments?
Yes, sir.
Is your judgment impaired in any way today?
No, sir.
Have you discussed these charges with your attorney?
Yes, sir.
Are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you?
Yes, sir.
You believe you're fully informed about your case? You understand that you do not have to enter a guilty plea here today?
Yes, sir.
You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea of guilty, I need to know that you understand those rights. I'm going to go down through the rights, and at the end of them, I'm going to ask if you understand all of them, okay? You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, the right to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against you. You have a right to produce evidence, a right to call witnesses in your favor, have a process issue to compel their attendance. You have a right to appeal this matter to a higher court if you lose, the right to require Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand by entering a plea today, you give up those rights. Do you understand that? Okay, I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. I do not have to accept the recommendation. Prior to accepting the recommendation, I will await a pre-sentence investigation report done by probation and parole. In the event that I do not accept the recommendation, the Commonwealth decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and go to trial. You understand that? Okay, you move to your left, please. What is the Commonwealth's recommendation? Now listen to this very carefully.
Upon a plea of guilty to operating a motor vehicle with alcohol concentration of or above 0.08 or while under the influence of alcohol or other substances, the The defendant shall pay a fine of $200 and cost. Possession of a controlled substance first degree, the defendant shall receive a sentence of 3 years probated for 5 years supervised. The defendant shall be referred to the social service clinician and shall follow all the recommendations thereof. The defendant shall receive credit for time served. The defendant shall obtain and maintain gainful employment or do a minimum of 30 hours community service per week until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style case disposed of in accordance with the laws of the Commonwealth and the holding agency. That any personal property held in evidence under indictment number 21 CR 18 shall be released to the defendant, and all other evidence related to contraband or drug paraphernalia shall be destroyed.
It was a sentence to be probated.
Yes, Your Honor.
Yeah. Is that what you agreed to?
Yes, sir.
Has anyone, including your attorney, offered you any other benefit for any of this plea? Are you pleading guilty because you did?
Yes, sir.
Knowing constitutional rights that I've explained to you, keep that just for a second. I'm going to ask you if that's your signature on that. Knowing your constitutional rights, I've explained, still your desire to give up these rights and allow the court to fit your punishment. You understand that after any guilty plea, any future convictions of a felony could be enhanced. You understand that? And also on the DUI, if you get another DUI, it could be enhanced and have a more severe penalty because of this plea. You understand that? Is that your signature on the document?
Yes, sir.
Okay, I will accept the agreement or the pre-sentence investigation report to be done. You'll be sentenced on August the August the 17th. You'll need to meet with the probation parole officer. You're under the same conditions you're bond. I'll let you know if we're on bond.
Thank you.
Okay, he's right over there in the blue shirt. Jason Spears. Caldwell versus Jason Spears, 22 CR 0084. Are you Jason Spears?
Yes, Your Honor.
Born in 1985.
Yes, Your Honor.
Last 4 digits of social security number 9019.
Yes, Your Honor.
You're here for a pretrial conference in 22 CR 0084.
Yes, Your Honor.
What's the Commonwealth have to say in this case?
Your Honor, we did receive the lab. I do have a copy, and myself and Mr. Stockton had agreed to set this for a final negotiation and pretrial next month.
August the 4th and August the 17th.
Thank you.
Thank you.
Allison Spivey Kennedy. Sentencing. Are you Allison Spivey Kennedy?
Yes, sir.
You born in 1981?
Yes, sir.
Last 4 digits of your social security number 7947.
Yes, sir.
You're here on 23 CR 0018 for sentencing. Have you had an opportunity to review the pre-sentence investigation report done by probation parole?
Yes, sir.
Does it appear to be substantially correct?
Yes, sir.
Counselor, is there any reason why this lady should not be sentenced today?
No, Your Honor.
On plea of guilty to controlled substance first degree, the defendant shall receive a sentence of 3 years, probated for 5 years, probation be supervised. She agrees to be assessed by social service clinician and following recommendations. Defendant shall have gainful employment until they do 30 hours per week of community service, should she not be gainfully employed. All paraphernalia shall be destroyed. What are the court costs in this case? 200 what? 240. You need some time to pay that.
Yes.
So you make your first payment 30 days from today for $30 and pay $30 a month and make sure you make those because they're doing. You'll need to meet with the probation and parole officer right over there. Okay. Alex Tooley. Sentencing. Commonwealth of Kentucky versus Alex Tooley, 22 CR 0039. Are you Alex Tooley?
Yes, sir.
Were you born in 1968?
Yes, sir.
Last four digits, social security number 3454.
Yes, sir.
Okay, you're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report on probation parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Is there any reason this gentleman should not be sentenced today, counsel?
No, Your Honor.
Defendant, upon a plea of guilty of possession of controlled substance first degree, the defendant shall receive a sentence of 3 years, probated for 5 years, probation be supervised. He agrees to be assessed by social services clinician and follow recommendation. 30, he should be gainfully employed. And if not gainfully employed, he should do 30 hours per week community service until he is gainfully employed. All the paraphernalia and contraband destroyed. What's the court cost in this thing? $215. You need some time to pay that?
Yes, sir.
Okay, make your first payment 30 days from today, $30 per month until it's paid, okay?
Yes, sir.
Probation parole officers right over there. Ansel Williams. Okay.
And everyone you called earlier, Sean.
Sean Jones. Yeah, which one? Is he on it? Was he on the active?
He's on the in-person.
Out of custody?
Yeah.
Yeah, I don't see it. Has he been processed? Okay. Hello.
Sure.
Are you Ansel Williams?
Yes, sir.
You born in 1978?
Yes, sir.
Last one is social security number 2279.
Yes, sir.
We're here on 23 CR 0042. Are you represented by counsel? Did you go to district court?
Yeah.
Did the public defender's office represent you there?
Brian Green.
Okay. You're here today for the purpose of arraignment. You have the right to remain silent during this arraignment. You have your attorney here works for the same firm that your other attorney did. The grand jury of Monroe County is returning indictment, charge you with possession of controlled substance, first degree methamphetamine. Do you understand that charge? Counselor, do you acknowledge the identity of your client, receive indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay. Negotiation day on August the 4th. And August the 17th is your next court appearance. Both of those are conditions of your bond, okay?
Your Honor, what is his current bond?
What is the bond now?
Check, Your Honor, because I did not realize he was in custody.
Yeah, just arrested.
$15,000 surely.
$15 surety, so he ought to be able to make that, okay? Now let's go back to Sean Jones. You got Sean Jones back there now?
Yes. Well, Sean Jones.
Cromwell versus Sean Jones. 23 CR 0043. Are you Sean Jones?
Yes.
You born in 1978? Last four digits, social security number 8640.
Yep.
Do you have an attorney?
Mr. Green.
Public Defender's Office will continue that appointment. This lady here is in the same firm that he's in, okay? The grand jury, you have a right to remain silent. The grand jury of Monroe County is returning an indictment charging you with possession of controlled substance of first degree methamphetamine, driving on suspended driver's license. Failure to maintain insurance. Indictment needs to be amended, it says, to honor about the 10th day of May. Is that correct? There's a note on here. Somebody put a handwritten note on here. Huh?
Since it's been dismissed.
Well, we could change the dates, but already been dismissed.
There were a lot of identifying information.
Okay. Okay, we'll just wait till the other indictment comes back on that. I'll keep this. And should I keep this here? Yeah, well, okay. Then you got improper registration plates. Just put that in the file there. Minus nothing. Slide, okay. You understand the charges, possession of controlled substance? Yeah. Driving on suspended and improper registration plates. Okay, well, you acknowledge the identity of your client, received indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
What's the bond on this?
Your Honor, if you just take into custody, I don't think that we pay for it.
$50,000 surety bond like we do. Okay. August the 4th, negotiation, and on August the 17th, and he's still in custody until somebody makes that bond. Withdraw that NCIC thing that we talked about earlier on. Okay, we got it. I guess that takes, we go into the Zoom. Simon Baker with David Cross. Simon Baker. What's the story on this? Mr. Hunley, you look like you'd have some pertinent information.
That case was in line to be dismissed upon the execution of two conflicting parties of an agreement to do so. We are awaiting, Mr. Cross represented Mr. Baker. He prepared a statement for Mr. Crow here to sign. Mr. Crow's names were erroneous all through it. And I told Mr. Cross last time I was in Clinton that if he would get us one with the correct names on it, that we would get it executed. I have heard nothing further from him.
Okay, well, was Mr. Baker supposed to be here today? It's on the docket.
We've been allowing him to appear via Zoom because he was absent. And the docket notation from last month stated that Mr. Cross would be allowed to appear via Zoom today because he wasn't able to be here in person.
We're prepared to dismiss it when we get.
I'll continue to August 17th. Y'all kind of tighten it up a little bit with him. You know, you got to tighten it up with Mr. Cross, okay? Brittany Carnes by Zoom. Brittany Carnes.
Yeah.
Go ahead.
Okay, Commonwealth versus, or they're not set up yet though, excuse me. Yeah. Commonwealth's not set up yet. Are you? You going back and setting up on a computer?
Yes, they're back there.
Okay.
Do we have to do that or can we just say?
Technically, you can say.
I want you to go back there and tell them they can stay in here and be picked up now that the computer system been changed. At the specific request of Mr. Bell, update our technology because we know he's kind of a wonk on those sort of things. Just awaiting AI to take over his life.
They had me on a couple of my eyes, Judge, back to that.
Well, like congressional hearing the other day, somebody said they're gonna talk about AIs and 4 of them yelled not guilty. That's right. Ms. Hill, they say you can be in the courtroom now and these things will work in here. We've got new technology.
Your Honor, I will head back to the courtroom.
Forward to seeing. Okay, now we've got Brittany Carnes here for review. If you want to come around to the microphone, Miss Gordon Anderson. We've got Brittany Carnes here.
Mr. Stockton was just, this was put on for pretrial just to see if she was still in Recovery Plus today.
And what do you want to do after that? Just
I think just continue it.
continue
Are you-
generally
Your
and
Honor, this was-
do what?
Your Honor, she is already on probation. This is on for a review just to make sure that she had been successfully placed in treatment. Me and Mr. Stockton sent Ms. Carnes to Recovery Plus, I believe, last month by agreement.
Okay, so I'll just wait till one or the other of you redocket this. Is that correct?
Yes, Your Honor.
Okay, thank you, Ms. Carnes. I hope you continue to do well.
Thank you.
Okay, the next thing we have anybody else here? The next thing will be Barron County Detention. Yes.
Mr. Schultz, attorney.
What do you have here? Yeah, okay, well, let's do that. Mr. Schultz, bring Mr. Schultz back out.
I apologize for the delay this morning.
That's okay. It's not so bad over at the Barron County Detention Center as some people say. Your client was here a few minutes ago. Here's your attorney. She's here now. This is Monroe Circuit case 23XX001, Monroe Circuit Court appearing to be an appellate court. In this case, on an appeal of District Court Case Number 22CI 22M rather 00152 Commonwealth versus Edward Schultz. You're Edward Schultz?
Yes.
Okay. I have read your brief here. You have a short statement. Primarily, you're relying upon Feretta, right?
Yes, sir. There were a few other appellate issues, but the primary issue in front of the court is the Ferretta issue that I believe requires immediate reversal.
I agree with you. Do you want to say anything else? That's good, isn't it?
I think that is good,
Yeah,
sir.
a
Thank
very,
you.
very pervasive, persuasive argument. I'll tell you, I read this thing and I'm in sympathy with the district judge, Mr. Schultz, because it appeared to me that they went into chambers one time to explain that, but you kept on, kind of interjecting and interrupting, and you had a script that you wanted to read and that sort of thing. But whatever reason is, I do believe that your rights were violated concerning being completely informed about the dangers of representing oneself and not knowing procedural aspects and that sort of thing. That's what Fred is all about. As a matter of fact, in one of the cases you cited that I really hadn't read before in detail, it talked about an experienced trial lawyer, criminal defense lawyer, being able to have a conviction overturned because he hadn't been had a Ferretta hearing. So I'm going to overturn your conviction and remand the case back for a new trial to the district court. And I don't know what the bond situation is, but I would assume that there was a bond set in district court at some time. I won't rule on a bond. What was it? Can you look at Mr. Mr. Schultz's case and see what the bond was in district court?
He was actually on a ankle bracelet and on a form of what I believe like a pretrial release similar to a home incarceration.
If he was on a pretrial release on an ankle monitor, I'll let him go back on that. And as soon as he makes arrangements that he can be released. Now, I don't want to give you any unsolicited advice, but next time I go in district court down there, if I was you, I'd have a lawyer with me. Okay, thank you very much.
And is it possible to have, I don't know if there was because he was on the bracelet, there was a bond plus the bracelet. Is it necessary to have both precautions in place?
That's not my decision.
Okay.
It'd be the district court's decision.
Okay.
And I really doubt that I have, as an appellate court, have any authority to affect the bond. Okay.
Thank you, Your Honor.
And we'll give you a short written decision on that. Okay. Thank you very much.
Thank you.
Mm-hmm. Okay, now. Are we at Barron County Detention Center now? Barron County Detention.
Yes, Your Honor.
Christy Allman. Don't be so loud, you wake Mr. Hundley up.
I like somebody with authority.
Yeah, that's right. Commonwealth versus Christy Allman, 21 CR 00128, pretrial diversion revocation. You're represented by Mr. Garrett, who's present here. Say something, Mr. Garrett.
I'm here.
I don't know where that keyed the mic. Okay.
It is Commonwealth motion, yeah.
Okay, please proceed. What is your motion to revoke his pretrial diversion? Call your first witness. Raise your right hand.
Summary, or I can just call Mr. Collins.
You swear the testimony you're about to give us the truth, the whole truth, and nothing but the truth.
I do, Your Honor.
Please proceed.
Take your name for the record and occupation.
Chase Collins, and I work with probation and parole here in Monroe County.
Did your office have as a client, Ms. Allman, in this case?
We did. Supervision began here in Monroe County on 5/20/22. We transferred her to Tennessee for supervision on 8/5/22. And
what's the process when you transfer someone to Tennessee that gives you the opportunity to keep up with their progress or lack of progress?
yes, we use a system called ICOTS, which is an Interstate Compact Offender Transportation System. That officer supervises that individual for Kentucky and notifies us of any new arrest or any problems that arises with that case.
Does the progress of that client become a part of your record then?
Yes.
Could you tell us the?
I'm gonna have to stop this just for a second. I'll be right back. Okay, excuse me. A short recess.
This is the one we done. This is one we done.
Sending them to us, like what they look like. We ain't got them yet.
How was the grant? That's nice.
Wasn't, 'cause he was not happy after. He was like a little grown man.
That's just revocation. Revocation.
Better, hopefully.
Is that her intake for down there?
No, looking at Chris, and not only has she failed me this term, I can't find anything that she can find.
Are you just ignoring? I'm just thinking it's still needed. That's why.
You don't know what it is.
I don't know, she's not educated, he has a lot bigger hesitation.
That kind of.
Exactly. Okay. Yeah, I saw that's all the same. So it was. That would be the case on the power. Yeah. I mean, I still don't.
It's on.
Right, right. See, they used to work with it. Now they have new technique.
Before you're done.
Right, yeah, right, exactly, that's like, I'm on this, but it should be. Exactly, okay, that sounds like a deal to me. Bad Company Farm. Do you know Bad Company Farm? You do? I'll be sending you a purchase. I'll be sending you a purchase contract. They need a time. And I need to look. St. Augustine, the other one lives right across the church line.
She took it on vacation. Probably needs a break.
They're, they're right. Yes, I know.
Couldn't avoid it either. I pulled right up to it.
Okay.
Let's go back on the record, please. You were doing your inquiry. Mr. Hunley? Yeah, you're still under oath. Please proceed.
Could you continue with the report that you received from the Tennessee Probation Authority relating to Ms. Almond?
Yes, on 4/27 of 2023, Ms. Almond was arrested and charged in Smith County, Tennessee for possession of methamphetamine.
Let's back up a little bit. When she was first, after she arrived in Tennessee, were any tests? Drug test, any kind of answers to her?
On 5/25 of 22, Ms. Almond was positive for methamphetamine. At that time, she was seen by the SSC on 5/27, and she was ordered to enroll and complete outpatient counseling.
Is this in Tennessee?
That was here before she wasn't accepted in Tennessee until August the 5th of 22. So that I would have administered that drug test.
All right, now on September 20th, 22, in Tennessee, did anything occur with her?
Yes, once she was accepted or transferred, was accepted in Tennessee for supervision. Miss Almond missed two scheduled intake appointments. She reported to an intake on 9/20/22 and administered a drug screen. She failed that for methamphetamines, cocaine, buprenorphine, and norepinephrine. A Lear lab confirmed these results on 9/25 of 22. Failed drug screen for methamphetamine in the state of Tennessee is a zero tolerance violation. She was also currently unemployed.
Was the employment of her in terms of her probation?
It was.
Go ahead.
Paperwork was sent over by paperwork was sent by Kentucky State. Subject was to complete 30 hours of community service weekly until employed.
Does it indicate how many hours of that 30 she served?
Stated that she completed 0 hours of community service.
Since then, have there been any more current violations? No.
Yes, on 4/27 of 23, Ms. Almond was arrested and charged in Smith County, Tennessee for possession of methamphetamine.
Now, I noticed that in the conclusion of your report that you recommend that a warrant be issued in the NCIC. Is she currently not available or?
At that time where she was supervised in Tennessee, basically I was stating once Tennessee probation and parole or any law enforcement in Tennessee arrested her, that we could get her transported and have a hearing in Kentucky.
All right, now your report was in August of this year. Excuse me, April 28th of this year.
Yes.
Can you tell me, from reviewing your files and what you know of this case, did she meet any of the terms of probation?
As far as holding a job, her drug use and receiving a new arrest, she's not met any of those requirements.
I noticed she also, if I'm reading it correctly, missed 2 scheduled intake appointments right off the bat.
Yes, it's what it looks like. Yes.
All right, and would you answer Mr. Carey?
Yeah.
What were the dates that she had tested positive?
It looks like a lab confirmed a positive on 9/25 of 22. She also had a positive for me here in Kentucky on 5/25 of 22.
Okay. And she was at some point charged with methamphetamine possession in Tennessee?
Yes, on 4/27 of 23.
a felony level or misdemeanor level?
The way I understand how Tennessee works, and I may be wrong, but possession of methamphetamine can either be a misdemeanor or a felony. And I believe at this time, the way the case was set up, and I called the clerk's office, it was a felony at that time.
So one of the recommendations that was made previously was for her to attend some sort of treatment.
Yes, I believe it was outpatient counseling.
And do you know what that date was that that recommendation was made before these other alleged violations?
On May 27th of 22.
That's all the questions I have.
Can you redirect?
No, yeah.
Any other witnesses?
That's the conclusion of our evidence, John.
Would you like to put on the evidence?
Ms. Almond, please.
You raise your right hand, please. Wait a second here. Camera back on. Would you raise your right hand, please? You swear the testimony about to give us the truth, whole truth, and nothing but the truth. You may inquire.
Ms. Almond, do you acknowledge that you had tested positive for methamphetamine while you were on pretrial diversion?
Yes, sir.
Okay. And have you tried to get into treatment at Evolve Behavioral Health?
I went into a 30-day treatment. I completed it, and I kept up with it while I was there, told I was doing what I was doing, and I was in sober living 2 days in when I got picked up for this. And actually, they're holding my bed for me.
Okay.
And
Let me have you to slow down speaking a little bit because we're getting an echo on what you're saying. So you were in Evolve before?
No, I got the charge, and I had talked to Chase, and I had actually went in for treatment on my own, and we had 2 deaths in 1 week, so I had to leave. But I went back into treatment, completed a 30-day treatment, and then I was in sober living, and I kept up with probation while I was there. Let them know where I was going and that kind of thing. And then I don't know, I got arrested while I was at sober living. I had just started it.
Okay, so the sober living was immediately after the other program that you were in?
It's cutting out. I couldn't hear you.
When did you do the inpatient or the other 30-day program that you talked about?
I had done it just right prior before going into sober living. I left the rehab and went straight to sober living on my own. I drove myself there, and I had been there for, I think, 4 days.
Okay. And since that date, have you been accepted into Evolve Behavioral Health on the Lebanon campus in Tennessee?
Yes, sir. They, I believe, sent a letter statement.
Okay, and I have that letter. Are you aware that it's a 90-session program containing, it's a partially hospitalized and intensive outpatient treatment?
Yes, sir.
And would you be willing to do that in order to keep your diversion?
Yes, sir.
And how many days have you been sitting since your arrest here in Kentucky?
40, I believe, or 35, 35 or 40.
Is there anything else you would like to add?
Just that, I mean, I was working, and I did complete those community service hours. I'm not sure what the misunderstanding is, but I did it at Smith County Health Center. I did do those things. So other than that, I just, my sobriety is what I was trying to work on. I took it upon myself to take myself there and complete it, and I'd like to try to finish it on out.
Nothing further, Judge.
Just a few questions. Ms. Almond, have you, in the course of your probation, have you ever had a successful drug test?
Yes, sir.
When was that?
I don't know the date, but I can, the guys, the one that administered, I can't, Daniel was his name, I believe. Dan Baker. It was, I'm sorry.
Where was that?
I did it at Lafayette whenever I went in for one of my reportings.
Is that the only one you can remember?
That's the only one that they gave me.
All right.
That's the one in the beginning, but I told Chase when I first started that I probably might need some, and then when they transferred it to Tennessee, I had a rehab call me, but they never called me back. So I was trying to, help myself along the way.
So part of this time you were self-treatment and you weren't under the auspices of either probation or parole, either here or in Tennessee. You were doing it yourself.
I took myself there, yes, sir.
Now, on April, the notes I see said that you were arrested in Smith County, Tennessee in April of this year on a charge of possession of methamphetamine. Is that correct?
Yes, sir. It was at the residence. It wasn't on me.
So were you with some other individuals that had been using methamphetamine?
Not that I knew of.
I see. Has there been any disposition of that charge?
No, sir.
Anything done about it?
No, sir. It's set out for a later court date, I believe.
I'm sorry, I didn't understand what you said.
I believe that court date's not come yet. I'm not sure.
You said that you had been employed. What were you employed at and how long?
I was sitting with elderly, a place called Home Instead. I had been there for about a month or so.
Where was that?
In Lebanon, Tennessee.
Who was your employer?
Home Instead.
Is that an individual or is that a company of some kind?
It's a company for people that sit with elderly people.
How did you find that employment?
On the internet, looking up jobs.
That you didn't get that through your probation or them to give you any assistance?
No, I did. I gave it to them. I gave them the information on it. I don't know why it's not showing up, but.
Where's your residence now?
My residence now, well, we left it.
Other than where you are?
It would be 11 Sammy Lane.
In Lebanon, Tennessee?
No, that'd be in Carthage.
Carthage. When did you go to Carthage then?
Well, I live in Carthage. That's where I live. So whenever I went to treatment, we left the apartment that I was at because the lease was up. So I just agreed to stay in with my mom.
So how many different places have you lived since your probation began here in Kentucky?
One.
Well, you've talked about being in Smith County, Tennessee. What county is that? Is that Carthage?
Yes, sir.
All right. Was that where your probation officers were after you left Kentucky?
Well, they would come down there certain times of the week to do home visits and see me. I think they worked partly out of that county, partly out of Putnam County. It's like a 30-minute drive for me.
How long has it been since you've had a clean test for methamphetamine?
It's been a few months.
Well, you've been incarcerated here for a while, haven't you?
I've been here, then before here, I was in rehab, and then before that, I was at home, but I did give them a clean drug screen. I'm not sure exactly how far back that was, but it wasn't too long.
Okay. All right, I don't have any further questions.
Any other witnesses?
No, Your Honor.
What do you have to say about this?
Judge, I would just say that Ms. Almond, like many other people who have been addicted to methamphetamine, struggles and will have a lifelong struggle to remain free of that drug. I think it goes without saying that there is a rate where people will slide back into those habits that's pretty high. And as this court knows, it's pretty difficult for people to come off methamphetamine. Ms. Almond has demonstrated, at least on her own, based on the testimony, without instruction by probation and parole or without instruction by anyone else, that she went to a rehab. She was trying to go into a sober living facility. because she herself has recognized that she needs help that with this issue that she herself cannot handle. She did take it upon herself and her family to get herself a bed at Evolve Behavioral Health in Lebanon. She has testified to that. I have the letter detailing the bed date availability. It is available now as soon as the court, if the court deems appropriate, releases her. This program is in Tennessee, Judge. She will be supervised by a Tennessee probation and parole officer. For this court's benefit,
Have you checked to see if they'll receive her down there?
Your Honor, I'll have to submit another transfer request.
I've communicated with the people at Evolve via email.
Well, they're a little funny about receiving people sometimes, but go ahead.
Well, Your Honor, this just simply says that this letter is to confirm that she's been accepted in our program and has a bed available upon her release.
It's not the same as the local probation parole people accept her. It's a different issue, isn't it?
Yes, Your Honor, yes.
Yeah.
Oh, as far as speaking to Tennessee probation and parole, I have not.
Yeah.
But if this court were to release her from this case, she would be free to return to Tennessee, whereupon whether or not probation and parole permits her to do so or not, she would still have that same bed available, even without their acquiescence. And therefore, permission from that probation and parole wouldn't necessarily be required because it's this court's hold on her at this point that restricts her freedom in order to go to that program. So Judge, we would just simply ask.
You're suggesting that she ought to be that she ought to be rewarded by being unsupervised to go down there to treatment center after she hadn't complied with supervision requirements. So what you're suggesting?
And that is absolutely not. I have never said that she should be rewarded with unsupervised.
Oh, we can't supervise her in Tennessee, can we?
We'd have to get that permission from them.
Yeah.
But I would merely ask the court to permit her to go to treatment there. Obviously, there has to be some supervision because the report that Mr. Collins has some items in it from which a probation and parole officer in Tennessee had to give him.
Who wants to respond to the Commonwealth?
My response is very brief, Your Honor. From viewing this, it would appear to me that the Tennessee Probation Department hadn't had anything to do with this lady since May of 2022, when she was ordered to enroll in and complete outpatient counseling. I can't find anything that Tennessee probation people did on this. Now, that certainly doesn't meet the terms of the probation that she got out of Monroe Circuit Court. Maybe it's not her fault, but it is a fact.
What do you want done with her, Mr. Huntley?
I want to revoke her, Your Honor, and that will get her out of the system. Maybe get her some treatment.
Judge, if I might.
Sure.
If the Commonwealth concedes that they want her to get treatment, I think it should not be dispositive of whether or not she receives that treatment if she is or is not in our system or in Tennessee's system.
Well, I just don't think that she's been in Tennessee's system, and I don't think she reported like she was supposed to or complied in any way. Where is she in the process now? Would she be able, if I revoked her, would she be eligible for shock or anything later on, or is she beyond that? Probation parole, what do you have to say about it? How much time does she have to serve?
Given a 3-year sentence, Your Honor.
She has some time toward that, though, doesn't she?
Yeah, the time she has now, I'd have to go back and look, but I don't know if she's spending any time in jail prior to being sentenced.
Yeah. Well, I'm going to revoke her to try to get her some help. I just don't think that she's been down in Tennessee. She needs more supervised situation to protect herself, and I think this is the least restrictive thing I can do to make sure that she gets some help. Okay, thank you very much. The next case is Keith Gross. Keith Gross. We all clear this area out here for the grand jury to come in. I'm going to have them come in just a second. Keith Gross. Commonwealth versus Keith Gross. Mr. Gross, were you born in 1979?
Yes, sir.
Last four digits, social security number 6977.
Sir.
You're here on a pretrial conference on 18 CR 00160, 19 CR 0053, and 21 CR 0061, and 22 CR 0098 for the purpose of arraignment. You have the Office of Public Advocacy that represents you in this case. One of y'all want to come forward? You have a right to remain silent. The grand jury of Monroe County has returned an indictment charging you with trafficking in controlled substance first degree first offense. Distributing methamphetamine. Counselor, you acknowledge the identity of client received indictment, waive formal reading and arraignment, interplead not guilty, get your all pretrial motions.
Yes, Your Honor.
Okay, now what does the Commonwealth have to say about these cases here?
Your Honor, we
You
were
want to
waiting-
come around?
We're just wanting to set it for a negotiation day, since he's just has a
August
new
the
arraignment,
4th?
and several others.
For negotiation in August 17th. Sign a reciprocal discovery order. Okay. Okay, thank you very much. Let's call a grand jury out now, just for a second, and then we'll come back and finish this docket. Grand jury will be here just for a second. All rise for the grand jury, please. Okay, everyone, let me see. Who's the full person of the grand jury? You finished your work? Okay, did nine or more of you vote on these things? Okay, present it to the bailiff and have a seat there. Looks like it's in order. What I'll do is sign the document to make sure that either summons or warrants are issued for the individuals that you've indicted, to make sure that they appear, or in a situation where they're a danger to the public, that the public is protected. It's still very important that you keep confidential the actions that you took there today for the protection of the officers and the individuals of the public. Does everyone understand that? Good. We'll be back here next on August the 17th, unless you're called in for a special grand jury. Not likely, but it could happen in the case of an emergency situation or an insurrection. These days you can't tell, can you? Okay, you're released. Thank you for your service. All rise for the grand jury, August 17th. Okay, let's return to the Barron County docket. Gary Hall would be next. Gary Hall. Representative Gary Hall.
Yes, sir,
Are you Gary Hall?
Yes, sir.
You born in 1978?
Yes, sir.
Last four digits of your social security number is 6975.
Yes, sir.
6975, last four digits social security number, is that correct?
Yes, sir.
Okay, you're here for the purpose of arraignment. Mr. Bell, your attorney's here. You have a right to remain silent. The grand jury of Monroe County is returning indictment charging you with assault in the first degree, possession of a handgun by a convicted felon, wanton endangerment in the first degree, tampering with physical evidence, terroristic threatening in the third degree, and being a persistent felony offender as to the assault first, wanton endangerment, and tampering with physical evidence. I'm handing your attorney the indictment, signing the reciprocal discovery order. Mr. Bell, do you acknowledge the identity of your client, receive the indictment, waive formal reading, arraignment, enter plea of not guilty, reserving all pre-trial motions?
Yes, Your Honor.
We'll set a negotiation day of the 4th of August. The next trial date is August the 17th. I mean, the next pre-trial date is August 17th. If you haven't reached your agreement, but then we can set a trial date.
Yes, sir, Judge.
Okay, Jonathan Hammer is next.
Your Honor, we filed a motion with this before on a motion to amend his bond.
Have you talked to the Commonwealth about it?
No, not much, Judge.
You want a hearing today on that?
Yeah, I'd like to be heard today if it was possible.
You want a hearing today on that?
Yes, sir.
Your Honor, please. Part of the evidence that Mr. Bell, I think, proposes to submit today on a bond hearing is an affidavit from the victim in this case. Certainly, I would object to any hearing in her absence because I do have the right to cross-examination, and I can't examine an affidavit.
Can you get the victim here today?
I could try.
Well, I'll be around for a while. We'll come back to the case.
Thank you, Judge.
Jonathan Hammer.
Oh, Your Honor.
Born Commonwealth versus Jonathan Hammer, 23 CR 0045. Are you Jonathan Hammer?
Yes, Your Honor.
Born in 1975.
Yes.
Last four digits of your social security number is 7337.
That's it.
We're here on 23 CR 0045. Do you have an attorney, Mr. Hammer?
Green from local.
Yeah, that's the Office of Public Advocacy. We'll stand in here. You're here for the purpose of arraignment. You have the right to remain silent. The grand jury of Monroe County has returned an indictment charging you with trafficking in controlled substance over 2 grams, Class C felony, resisting arrest, fleeing and evading police in the second degree, and PFO, being persistent felony offender as far as the trafficking charge is concerned. Counselor, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty,
Yes, Your Honor.
reserving all pretrial motions.
Yes, Your Honor.
Okay, I'm signing a reciprocal discovery order. Mr. Hammer, to give the attorney the evidence the Commonwealth has at this time. We'll set a negotiation day on the 4th of August, and the next court appearance is the 17th of August.
Thank you.
Okay.
Your Honor.
Shelley Horton. Shelley Horton. Commonwealth versus Shelley Horton, 22 CR 0094. Ms. Horton, were you born in 1996? Last four digits, social security number 5014. Represented by Mr. Garrett. It's pre-trial conference. What does the Commonwealth have to say?
We have a felony plea, Your Honor.
Okay. Ms. Horton, a motion has been tendered that says you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Hello?
You have to speak up so that you. Yes,
Are you the same person named in indictment 22 CR 0094?
yes,
Have you had plenty of time to discuss this matter with your attorney, and are you satisfied with his advice?
yes,
Have you reviewed the evidence the Commonwealth has against you, and you feel like you're fully informed about your case?
yes,
You understand that you don't have to plead guilty today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea from you, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, and the right to appeal this matter to a higher court if you lose. You have the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges against you. And you understand that by entering a guilty plea today, you give up those rights. You understand that? Do you understand that?
yes,
Okay. I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting the recommendation, I will await the pre-sentence investigation from probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and guilty and proceed to trial. Ms. Gordon Anderson, will you come around behind the microphone and listen very carefully what the prosecutor has to say? Please proceed.
Upon a plea of guilty to possession of a controlled substance, first degree, the defendant shall receive a sentence of 3 years, probated for 5 years, supervised. The defendant shall be referred to the social service clinician and follow any and all recommendations thereof. The defendant shall receive credit for time served. The defendant shall obtain and maintain gainful employment or do a minimum of 30 hours of community service per week until gainful employment is obtained. The defendant agrees to have any and all evidence in the above styled case disposed of in accordance with laws of the Commonwealth and the holding agency.
Is that what you agreed to, ma'am?
yes. Yes,
Are you pleading guilty because you committed the acts charged in the indictment as amended?
yes,
Are you doing so of your own free will?
yes,
Knowing your constitutional rights as explained, it's still your desire to enter this plea and allow the court to fix your punishment.
yes,
No, this was a probated
Yes, Your Honor.
situation. You understand that after entering a plea of guilty, any future convictions could be used to enhance the range of your penalty. Do you understand that? Do you have the agreement with you?
Judge, it should be in the file. This is one that we tried to do last time and the court wouldn't let us do it.
What was the problem last time? She wouldn't speak up or she was under influence?
One of those.
Yeah. Did you sign this document here that's in the file saying you want to enter a plea?
yes.
No. Is she to serve any additional time? How many days has she been in? Yeah, how many more days in contempt does she have?
And just,
What are y'all suggestions she serve in this agreement? I don't have a copy of the agreement in front of me. Can you just tell me?
Additional times?
What's the total? How much time is she gonna get probated?
She's going to get 3 years, probated for 5 years.
Going to drug court or anything?
no, Your Honor.
Social service.
Just a social service clinician was who was going to get a
Well, I'll
report.
order a pre-sentence investigation for it, then probation parole. And she'll be here on the 17th for sentencing.
But could she be released today?
No, I'm not gonna do that. She came here intoxicated last time with 3 or 4 different drugs on there. And I'll let her out on that day if I accept the plea, okay? Thank you. Justin Hunt. Justin Hunt. Versus Justin Hunt, 23 CR 0033 for arraignment. Mr. Hunt, were you born in 1980?
Yes, sir.
Last 4 digits of your social security number 3108.
Yes, sir.
You're here today for the purpose of arraignment. Do you have an attorney?
No, sir. Well, I think court appointed attorney.
Okay, well, I'll continue that appointment from district court. You have a right to remain silent. Your attorney is here in front of me. We're going to do the indictment. Read the indictment. The grand jury of Monroe County's returned an indictment charging you with theft, unlawful taking, or disposition. Less than $1,000, and then 3 additional counts of theft, unlawful taking, less than $500. And then they have charged you with theft, unlawful taking, and disposition, more than $10,000, but less than $1 million, 2 counts. And then theft, unlawful taking of services. Theft, unlawful taking enhancement on both those. All right, you understand those charges. I'm signing a reciprocal discovery order. It requires Commonwealth to provide your attorney with information about your case. You acknowledge the identity of your client, receive the indictment, wait for an arraignment, enter plea of not guilty.
Yes, sir.
Okay. Okay.
Your Honor, is there any way to lower the bond?
The negotiation day would be on the 4th of August, and the next court date's on the 17th. What is this gentleman's bond?
Your Honor, it's 25,000 cash.
What does the Commonwealth have to say?
I could say something, sir. I have a job.
Mr. Hunt, I'm going to advise you not to make any statements regarding the case itself today.
Just looking at his criminal history, it seems to be pretty lengthy. He was indicted for PFO second. We would oppose any reduction.
Okay, I will let him reserve, and you can set a bond here. Your attorney's going to come over and talk to you. So you'll be prepared for a bond hearing. You're allowed 1 bond hearing by right, and I don't want you to burn it up today until she's prepared to argue your bond change, okay? And you can tell her all the information about your job and whatever it is that makes you think that you should be a good risk, okay? So I'll reserve that for you. Thank you very much. Brian McNeese. Commonwealth versus Brian McNeese.
Judge.
Brian McNeese.
It's not here, Your Honor.
Judge, this is Kevin Crossland's case. I'm standing in for him today. If the court would just put this over to the next date.
Where's Brian McNeese?
I have no idea. I thought he was in custody.
Allen County, I think. I believe he went to court in Allen County. I'm not for sure. I can go look for you real quick.
That'd be great. While we're doing that, we'll look at Terry Muse. Terry Muse. Y'all have Terry Muse there?
we had Terry Muse in here, Your Honor, and he said that he was told that he didn't have to be in here today and left the courtroom. Do you want me to go get him?
Yes. Is there any reason why he wouldn't be here today for arraignment?
I don't think his attorney is here.
Where is his attorney?
This was our motion to revoke.
You also have an arraignment here, it looks like.
Oh, yeah, in arraignment on a new charge, yes.
So I'll let somebody stand in on arraignment and we'll schedule it out.
And- Your Honor, Mr. Stockton received a text from his attorney, and his attorney wanted to know if he could appear by Zoom or by phone.
Be good to call us and ask us about it. I don't know. I'm gonna let somebody else stand in for arraignment.
So Mr. McNeese is being transferred to Allen County.
I said they had him there.
No, she said
Oh,
she
Mr.
wasn't.
McNeese, yeah. Said she thought he'd gone to Allen County to court.
Vine shows that he was transferred.
Okay. We'll trust Vine. What do you have?
Order regarding the final disposition.
Hopefully that will be what you want. If not, I can redraft it.
I think it should have probably now it's remanded to the district court for a new trial. Don't you think so?
Thank you.
Are you Brian McNeese?
No, sir.
You're Terry Muse. You're Terry Muse then. We can't find Brian McNeese. That was the answer to that. I think he's in Allen County. Are you Terry Muse?
Yes, sir.
You born in 1985?
Yes, sir.
The last four digits, your social security number 2055.
Yes, sir.
Your attorney is Philip Campbell, evidently communicated. Are you online, Mr. Campbell? Philip Campbell,
He's wanting to appear by phone.
Mr. King, would you turn your camera off?
Oh, that's what I should go.
So I don't see your attorney here. I'm going to just have someone to stand in for the purpose of arraignment. I'll ask public advocacy for arraignment only to stand in. You have the right to remain silent, Mr. Muse. Suggest you exercise that right. The grand jury of Monroe County has entered an indictment charging you with intimidating a participant in legal proceeding, terroristic threatening, third degree, and being a persistent felony offender as far as intimidating a participant in the legal process. You acknowledge the identity of this individual here. You receipt the indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving pretrial motion. I'm going to sign a copy of the reciprocal discovery agreement, Mr. Muse, and we will forward this. You can give it back to Commonwealth. We'll forward this information to your attorney, Mr. Philip Campbell, who said he was going to try to appear by phone, but there's a lot of bad weather going on. So I'll give him the benefit of the doubt on that. We'll schedule you to be for a negotiation day on August the 4th. And then you'll be here in court next time on both these charges on August the 17th, and the Office of Public Advocacy can be relieved from any further obligation. Thank you. Jeannie Ramos.
That we also had a motion to revoke on for Mr. Muse.
Well, I'm not going to do that until his attorney's here.
Okay.
I mean, I know it'd be easier for you to do it without his attorney, but it probably frowned upon.
Can I tell Mr. Carlson that'll be set on August 17th? McNeese.
That was Cherry News. I just finished.
Oh, okay. If we, on McNeese, we didn't give a date.
Yeah, well, I don't know.
He was standing in for his attorney.
Yeah. So just tell them to put on negotiation day for the 4th
Okay.
and the 17th.
He'll need to do the transport.
Okay, I'll let him know.
Yeah, they don't like Zoom without it yet. Jeannie Ramos, are you Jeannie Ramos? Okay, you born in 1978. The last four numbers of the social security are 5570.
Yes, sir.
You're here on 22 CR 0051, a probation revocation. You're represented by Mr. Garrett. What does the Commonwealth have to say about this case?
It's our motion to revoke, Your Honor.
Come around and make the motion.
This is our motion to revoke, Your Honor, and we have a witness to call.
Okay. You want to stipulate? Oh, okay. Bring your witness around. Raise your right hand, please. Swear the testimony about to give is the truth, the whole truth, and nothing but the truth.
I do, Your Honor.
Identify yourself and with whom you're employed.
Chase Collins, and I'm employed with probation and parole.
You may proceed. May inquire, Ms. Gordon Anderson.
Ed is one of the.
You need to get over here and speak up a little bit.
One
Use
of the
your-
individuals that you are supervising, is it Jeannie Ramos?
Yes.
Okay, and when did she go on probation?
His supervision began on 3/7/2023.
Okay, and then since that time, has she had any violations?
She has.
Okay, will you please tell the court what those violations are?
On 3/21/23, Ms. Ramos signed an admission form for the use of methamphetamine about 3 or 4 days prior to that date. On 5/18, she signed an admission form for the use of methamphetamine on about 2 weeks prior to that date. And on 6/7/2023, Ms. Ramos was given a urine test and showed positive for methamphetamine. She also signed an admission form for admitting that she was in a camper with people smoking meth. It was very adamant that she never used, and she couldn't understand why she was positive. And then on June 16th, after we left court here, Your Honor, you ordered a lab test. She reported probation and parole on June 16th. Upon arrival, she was asked to provide a urine sample for purpose of a drug test. She provided the sample, which field tested positive for methamphetamine. She again denied use, and the sample was sent to the lab for further testing. The drug test report showed positive for methamphetamine. Amphetamines was positive, which is 1,904 ng/ml. Cutoff is 50. Methamphetamines was positive. It looks like it says 12,500 ng/ml, and the cutoff there is 50. So she was positive for amphetamines and methamphetamines. The lab test came back.
So since being under supervision, she's had 4 positives for methamphetamine.
But that's correct.
And the first 2, she had an admission. She admitted that she had been using.
Yes.
And then the second 2, she denied use, even though there was a drug test.
Correct.
Were positive. Okay. I have no other questions.
Do you have any inquiry?
I do, Your Honor. Can you tell me whether or not it's possible that any drug she may be taking could show positive for amphetamine or methamphetamine?
I'm not a pharmacist nor a doctor, so I can't elaborate on that.
Has it been your experience that if somebody tests positive for methamphetamine or amphetamine, is that a accurate test to show that it was indeed the illegal substance of methamphetamine that was in their system as opposed to some prescription?
I know certain prescriptions can be amphetamine, but what we're worried about here is the methamphetamine. And from what I understand, the way our tests are made is it has to be the chemical makeup of methamphetamine to test positive for that drug.
Okay. If I had a prescription list of her, you wouldn't be able to tell whether or not any of those would test positive for methamphetamine.
No.
Because you said the test actually shows what the illegal substance is.
Yes.
Okay. Did Ms. Ramos ever ask for any sort of treatment or anything of that sort during this time period?
She was currently going to believe it was outpatient counseling.
Okay.
So she was attending that treatment up until the last drug test, and then she was placed in custody on 6/15. So she was in outpatient counseling, to the best of my knowledge.
Would it be possible for her to go to some sort of short-term treatment in lieu of revocation, or?
We would have to have her assessed by our social service clinician. They would have to make that recommendation.
Nothing further.
Is she eligible for drug court?
It's a.
It's a
I'm not
diversion.
sure if she is or not. I don't think she's ever been assessed.
I think she may have medications, Judge, that she has to take because of her seizures and stroke that could prohibit her eligibility for drug court, although I'm willing to.
Okay, you have a witness.
I don't have any questions for him. Yes, I would like to ask Ms. Ramos.
Mr. Ramos, you raise your right hand, you swear the testimony, you raise your right hand, swear the testimony about to give us the truth, the whole truth, nothing but the truth.
Okay.
Please proceed.
Ms. Ramos, is there anything you would like to tell the court as an explanation for the positive drug test?
I would like to apologize. I've been addicted to meth since 2018.
Okay. You're going to have to speak very slow because we have a serious echo when you speak fast.
I would like to apologize. I have been addicted to meth since 2018. I tried to kill myself because of my addiction, and that's why I had my stroke. I tried to take Wellbutrin as I was advised to do through my probation officer. He sent me to for counseling. So they gave me this medication and I was taking it and I was trying to be good, yet I failed. And I would just like to apologize and ask for help.
Ms. Ramos, would you be willing to do any sort of treatment if the court would permit you to do that?
Yes, sir.
That's all I have, Judge.
I don't have any questions.
Did you ask her if she was taking methamphetamine?
Ms. Ramos, the past 2 drug tests that you have taken and have come back to be positive for methamphetamine, were you taking methamphetamine at that time?
I was trying not to. I was taking Wellbutrin. They gave me that too, so I wouldn't take it. So I wouldn't take methamphetamine.
Now, the 3rd drug test that you took, whenever.
What was her response to that?
Can you please?
Were you taking methamphetamine?
Yes.
Okay. Go ahead.
And to the second time that you tested positive, you stated to you stated to the probation and parole officer that you had been in a trailer with others that had been smoking methamphetamine as well?
I have been high since 2018.
I have no other questions.
No other questions.
You want to make an argument?
Yes, Judge. I would just ask the court to permit her to either be evaluated for some sort of treatment, or if the court's willing, I can follow up and see if I can get her a fed date for a facility.
You want to come around and make an argument?
Your Honor, we don't oppose any type of treatment for her. Obviously, she's got a serious problem. We are here to.
Well, I'll take this under advisement, and then you try to get a treatment situation that's the Commonwealth is amenable to, and I'll be willing to sign and agree some sort of agreed order. Now, Mr. Ramos, let me tell you something. You're involved in very dangerous activity with your drugs and your health issues, your stroke and that sort of thing. I'm going to give you an opportunity to go into a treatment situation, okay? But you're going to have to take responsibility. And if they're going to have to agree on what kind of treatment that you're going into. But I don't want to pick the newspaper up and see an obituary over in the Glasgow Daily Times or whatever they call it over there now. You're very close to getting yourself in a situation where you won't come back from it. You understand that?
Thank you, sir.
Okay, so you try very hard, and there should be an order coming over when we find a long-term treatment for you. Okay, do we have anybody else that needs to see us at Glasgow there?
Mr. Webb, Your Honor, he was the transported her.
Joe, we didn't know he was there, isn't that right?
No, he was the one that was, I think it was Tommy Webb, he's the one that was supposed to be transported.
Agreed to lower his arm.
He's on the transport.
It's right here.
Yeah.
Tommy Webb the third. Is that correct?
Yes, Your Honor.
Tommy Webb the third, Commonwealth versus Tommy Webb the third, 19 CR 0073. Are you Tommy Webb the third?
Yes, sir.
Born in 1998.
Yes.
Last four digits, social security number 3770. Is that correct?
Yes.
Okay, what does the Commonwealth have to say about this case on the pretrial diversion revocation?
Inform the court of the circumstances where we are today. Jesse and Lauren had agreed, I think, prior to the yesterday or today, that if he could get into drug court, Jesse would let him go to drug court. He was confirmed this morning, approved this morning to enter the drug court here in Monroe Circuit. Then we found out today or this morning or yesterday that there is a warrant out now in Tennessee for his extradition back to Tennessee, which Lauren didn't know, neither did we. So
What is the warrant for?
I'm not sure, Chase.
Your Honor, I spoke, when we transported Mr. Webb to the Marion County Jail. Trooper Maxwell stated there was an extraditable warrant out of Tennessee. Mr. Webb stated that, if my memory serves me correctly, it had something to do with a handgun and drugs from Tennessee.
Other than that, what?
That's all I know of.
Have you seen
I
the
don't know.
extradition warrant?
I can't. I just Trooper Maxwell.
Well, what I'm going to do is take this under advisement, this pretrial diversion revocation, and we'll, if y'all reach some resolution, find out what's going on in Tennessee, you can come back to me.
Setting this for next month so we can get more information done.
August the 17th, and yeah, let's put a negotiation date on August the 4th. Do what?
I'll see it, Your Honor, and let him know what's going on.
We lost Glasgow. It's not a new experience. It's not a new experience for me, Mr. Bell, to lose Glasgow.
Well, I think you did better over there.
Yeah, it's timing's everything in it, We got one more over there. Somebody try to get them on the line and see why we lost the contact.
Tracy.
Who else did we have?
Nicholas Howland. He's on the out of custody docket with the active warrant, but he turned himself in martial.
Nicholas Highland. Okay, well, let's go off the record until we find out whether we have them or not, okay?
I just have the updated order, sir. Do you want me
Come
to
on up.
approach with that?
Come on up.
No, she didn't talk to. No.
I see he hears.
Can you hear us?
Nope.
Nicholas Highland. Nicholas Highland.
No, he didn't. What was that?
That's the last
Can
one.
you hear us, Your Honor?
Yeah, Nicholas Highland's the last one we have. Do what? Yeah.
Mr. Webb says he didn't get to hear any of ours. That's when our internet went down.
Mr. Who?
Mr. Webb. He was the one you was with when the
We're
internet.
gonna, what did we end up?
We put him on for settlement conference in August and then for a hearing date.
There was a warrant in Tennessee.
Yeah, so Mr. Stockton.
Mr. Webb, there's a possible warrant they brought up in Tennessee that they have that involved, maybe have a weapon on it. I don't know anything about that, so don't you say anything about it. Your attorneys advise you not to say anything. But for your protection, we're gonna let her have the opportunity to investigate that. And we're setting you on a conference date, a negotiation date for August the 4th. And then your court date will be on August the 17th, unless they find out that the information about the Tennessee warrant is not correct, and I'll consider doing something on an agreed order, okay? Okay, thank you very much. Nicholas Highland. Nicholas Highland. Commonwealth versus Nicholas Highland. 23 CR 0041. Are you Nicholas Highland? Are you Nicholas Highland? You born in 1998?
Okay.
Last four digits of social security number 9453. You have an attorney, Mr. Highland?
I had one appointed one.
Okay, well, we'll continue that appointment with the Office of Public Advocacy. You have the right to remain silent. Your attorney is present. You see her coming on camera there. The grand jury of Monroe County's returned an indictment charging you possession of controlled substance in the first degree methamphetamine. Mr. Bailiff, counselor, do you acknowledge the identity of your client, received indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions. I'm signing the reciprocal discovery order here that your attorney's going to get the evidence Commonwealth has against you. Set a negotiation day for the 4th, and your next trial date 17th. What was the bond that I had on this case here? On the warrant?
I believe it's 15,000 clerk approved surety, Your Honor.
There is a 15,000 clerk approved surety on here. Sure, that's not a very high bond, so you can get somebody to come over and make that bond for you, okay? And then both of these appearances, the 4th and the 17th, are conditions of your bond. Okay, thank you very much. Glasgow, do you have anybody else for me here?
No, Your Honor. Thank you.
Thank you for cooperation. Have a great day.
You too, Your Honor.
Yeah. Okay, does that conclude the docket except for Mr. Bell? Mr. Bell, you just work on getting your, and if you feel very strongly about it, I can schedule a hearing some other date for the next real day.
Would the court allow us to get the 50,000 cash or 100,000 property?
Well, what's the bond now?
50,000 cash.
And an ankle monitor.
Yes, sir.
That's what the bond is. I have no reason to change it upward. Mr. Hunley would like to take it to $1 million, but it is what it is.
I think there is a danger in this case, Your Honor.
Well,
I'm not going to be part of reducing the bond.
well, I'm not asking you to. I'm not going to without hearing.
I'm not asking to reduce it. I'm just asking it to be 50,000 cash or 100,000 property, equivalent to what it's already set, and the statutory language supports that request, Judge.
What do you have to say about that?
I think that's totally in the discretion of the court, and it should follow a
Well,
hearing.
bring the statute out. You got the statute?
I don't have it with me.
Well, I'll give you time to get it. Hand him it. Is it this book up here?
It's in the green book.
Right, here's the green book right here. Come up here, reach over there and get that green book. I'll let you. And we'll go off the record while you That's the last time we used it, 2017. Okay, let's go off the record.
Hey, John, there's a new version of Judge Christie.
We all can get it on,
22,
y'all can get it
that's close.
online. Can you get it online, pull it up for, what's that citation, Mr. Bell? And they'll get it online for you.
I've got to find out. I filed it in other court.
We're off the record, aren't we?
I've had it granted.
Well, let me get that.
That doesn't matter. Circumstances, Your Honor.
Tell me what the circumstances with this bond is that you think it's not adequate.
Well, I think that the circumstances of the change in the story of the victim gives rise to perhaps other crimes in the Commonwealth of Kentucky.
You think you're afraid she might be intimidated or something?
I would like the opportunity to question her.
I don't think that's inappropriate to allow him to question her because she comes up and wants to recant. And you know, he can, I guess they can interview her without going on the record, maybe. Do you have any officers here or anything that could interview her?
They have spoken with her. The victim advocate has spoken with his witness or my witness, whoever the witness is going to say she is, much prior than I did.
I wasn't aware of that. See, I don't talk to people about these cases, so I didn't know that. Has your victim's advocate talked to the lady that she wished to recant?
I think so, yes.
Yeah.
I don't necessarily believe it's
After the fact.
recanting, Judge. It's just a reason as to why the story was told.
Well, if she doesn't recant, it doesn't matter what she says. If this happened, now she doesn't want to, go forward with it. I had another case like that today where the person didn't want to go report. You were present. Was that your client too? Yeah. Where the person come over and shot a gun in the direction of somebody, and now that he was marrying a girl that they were fussing over, now they didn't want to proceed with it. Well, that didn't matter too much with me because the gun was fired in the direction of somebody, and we're going to take a look at it. Now, in this situation, there was an assault one, allegedly. I'm interested in seeing what she has to say. Huh?
And possession of a firearm by a convicted felon,
Yeah.
perpetrator of the assault. Now the lady wants to say, I didn't see any guns. I don't know who shot me. I've never seen a gun in that house.
Well, if he's going to testify, I'll swear him in. I've been wanting to have a question him for years.
Well, I'll let you testify. You've been more
I'm
effective.
just reading the affidavit.
You got more experience testifying than he does.
I'm just reading the affidavit that's attached to Mr. Bell's motion.
Well, Judge, she's here.
Yeah, bring her up here just a second. Bring her up here. Let's style this action here.
It's 23 CR 00040, Garrett Commonwealth versus Gary Shannon Hall.
Which list is that on? Yeah, we'll have to get him on there. We'll have to call Glasgow back on. He's got a right to be. Let's see this. Gary Hall. Call Glasgow back up and see if we can get them back on.
Ready. Oh, we got
Somebody calling Glasgow. Say. Somebody calling Glasgow jail. Yeah, I'll be good. Johnny's got him on speed dial.
Exactly what she said.
I used to hear about them over in circuit court, Judge Williams is warning Gary Hall back on. Sunday. Yes, ma'am. Okay. Yes, ma'am. Thank you. Thank you. Bye.
Do I have that affidavit? Megan?
It's attached to the motion, Your Honor.
Received the motion, it wasn't even on the docket.
Wasn't on the docket. It's not on the docket.
I did look and you did follow it.
Yeah.
Now, Mr. Hunting was referencing the police report. I have not received any evidentiary matter up to this point.
Hmm. Let's go off the record. We at Glasgow here. Okay, Marion County. Got Mr. Hall, see what we're looking for.
Yes, sir.
Yes, Your Honor.
Got Mr. Hall there, yeah. Okay, Mr. Hall is there. Mr. Hall, there's an issue up about your bond and Mr. Bell wanted to bring a witness. Is that right, Mr. Bell, or you want to come up for me?
No, I'll put it on.
Yeah. Which one do you prefer, Mr. Hunley? You want to call a witness or you want the defendant to call a witness?
Well,
what, for the record, the concern during the break, the concern was an affidavit that was attached to a motion that Mr. Bell made that I was unaware of, that was brought to my attention in the presence of Mr. Bell and Mr. Hunley, where the alleged victim has recanted as far as the story is concerned. Mr. Hunley has raised concern that the bond might not be sufficient after considering that. Is that right, Mr. Hunley?
Would be part of it, yeah.
And Mr. Bell is alleging that they're entitled to make the cash bond with property or other things of value pursuant to the statute. So we called the witness to testify concerning that because Mr. Hunley wanted to address the issue of the bond. Okay, Mr. Hunley, I'll let you.
In the complete interest of justice, Your Honor, I think this young lady should certainly be advised of the danger she may be subjecting herself
Well,
to.
we're going to call her up here, and you can come up behind the podium here. Okay, now, yeah, no, right here, this podium right there. Now, state your name, please.
My name is Angela Renee Moons.
Okay, now, ma'am, you previously made a complaint or a statement concerning Mr. Hall, and now you have signed a sworn statement that was notarized by a notary in Mr. Bell's office. Is that correct?
That is correct, sir.
Okay. Now, you got two possibilities. You could possibly be charged with making a false police report, or because in that document you said you lied to the police, which is not a crime in and of itself unless it's for some purpose a false report. Now you've done a sworn statement that you don't know who shot you. So I want to advise your rights and to see if you want to obtain an attorney or do you want to go ahead and tell your story?
I could just tell my story.
Okay, well, I just want to advise you. Mr. Hunley, you want to inquire?
Yes.
Okay.
And Judge, is this going to be limited to the simple scope of Mr. Hunley's statement that there had been a change or that she could possibly be intimidated or somebody might be driving this to have her to do this? I mean, I think that's the scope.
We'll just see where it goes. Anything you want to object to, I'll give you.
I have a recorded statement.
Well, wait a second. You go ahead and ask your questions. If he wants to object to anything, I'll rule on the order of order, okay? Go ahead.
Ms. Mays, you are the victim in this case, are you not?
Yes.
You, on May 2nd of this year, you were shot, weren't you?
It was later in the month. I had it was it was the week before 4th of July, I suppose. It might have, everything has been so crazy. I have had a grandchild on top of that through all this. May the 2nd is what I had picked, but I was shot. Yes, indeed, I was shot.
Now, do you remember when the emergency personnel and the officers arrived at your house?
I do, in fact. I was starting to, at that time, it had been a little bit longer than what I had expected or wanted when they did arrive, because we had thought the law had been called prior to that.
What injuries did you receive?
I received got a plate in my arm. My right arm just was messed up a little bit.
Did you say a gunshot in your right arm? Move closer to the microphone. No, stay behind the podium. Move closer to the microphone and speak into the
How did you
microphone.
know it was a gunshot?
Just by the sounds of it, I had heard. That's what got everyone out of the scuffle. And I remember looking.
Go ahead. Do you remember talking to the officers and the EMS crew right after they all got there?
When they got there, I do remember being placed into the
Do
ambulance.
you
and
remember
talking.
them asking you what had taken place there?
I do, and I do know what I said to the officer, because at that time I was going in shock and I did not exactly know. I knew I'd been shot.
What exactly did you tell them then?
Well, as far as I remember, I told them he had shot me. There was two he's there.
You
that night.
stated that Gary Hall had a small handgun that reminded you of the one that you had owned at one time.
No, sir, I did not state that the night that I was in the ambulance.
While you lived in,
Because
I'm talking about while you were there at the house.
That was the night of the shooting.
Yes,
That's what I just said.
and that you were looking at the gun and that you accidentally shot yourself.
And I had to, at that time, I was, you gotta admit, Shannon, and then I have a brother that is a convicted felon. At that time,
Did you tell them?
Wait just a minute, Mr. Hunley. Let her tell her story. Go ahead.
Go ahead.
I was going in shock and I just didn't want neither one of them to get in trouble based off of them being in trouble before. I don't know who shot me, but I do know that my brother did not stay there, call the ambulance, didn't care if I lived or died. When we thought that he did. I just became a grandchild, and it's later that I had found out that my brother said some other things that were so very untrue.
Let's kind of stick to the topic here.
I'm sorry.
Your
I
life story
apologize.
is interesting, but we're here to talk about
Yes,
what
sir.
happened that night. Okay?
Yes, yes.
So basically, the first story you told the officer was that Gary had a small handgun, you were looking at it, and you accidentally shot yourself with it.
Judge, I want to check. She answered, she did not say that.
No, let him answer.
Sir, I'm not quite sure. Gary did not have no gun. The gun gunfire scares me. Gary never had guns that I knew of. I've been in his house almost a year. We had set the house up for my grandchild to come there. My kids still come there. I still have an 11-year-old that stays there part-time with me. I'd never seen no guns. When the night that happened, my brother had been scouring around all day long. You could tell he was up to no good. He's been in.
Wait just a second. Respond to the question. The question was, you stated that night that Mr. Hall had a gun that looked like a gun that you used to have. Do you remember saying that?
No, I don't, sir.
Go ahead.
I'm sorry.
You know, you did tell the officers that it had accidentally discharged and basically you had shot yourself.
Yes. If that's what's written down, I didn't ever say that Gary had a gun. I've never seen Gary with a gun at our house. I said I lived there with him almost a year.
Well, you were shot in that house that night.
I was shot in that. I was.
And you're saying you shot yourself.
No, I'm not saying that. I'm not saying that.
Well, what are you saying?
Well, what I'm saying is I don't know who shot me. I know they got into an altercation because Brian was caught stealing. And when Shannon asked him to unload his pockets, he unloaded his pockets and it was our stuff in there, in his pockets. It was his stuff in there. And they got into,
Who's they got into it?
Brian, which is my brother, Gary or Shannon. They got into a scuffle and I got in the middle of them to try to break it up. I was just trying to break it up. And I don't.
Did you have a gun when you got in the scuffle?
No, sir.
So either your brother or Mr. Hall one had a gun.
There's no gun to be found. There's like it.
But somebody had a gun.
I understand that, but what I'm
just
saying
trying
is
to
like
find-
when
you
my
answer Mr.
brother,
Hunley's question.
when my brother left.
Ask Mr. Hunley's question.
Yes, sir.
Now, later, do you recall receiving a telephone call, a conversation with Officer Ty Hammond?
It was been long time after that, about a month.
Well, it was.
I'm going to renew my objection. Your Honor.
Overruled. Go ahead. I just wanted, go ahead. Here, Mr. Hunley, rather than go over all these statements.
I'm going to play the recording.
Well, I don't know. Here's the thing about it.
I had.
Wait just a second.
Yes.
Here's the deal about it. We've got a victim here that says that her brother and her boyfriend got into a fight over some stealing, that she didn't have a gun. So one of the other of them bound to have had a gun and she got shot. She's saying she doesn't know who had the gun. That's what she's saying. And what she told anybody else any other time is contradictory to that. Obviously, there's no reason to go into what she said is
Not
contradictory.
just contradictory, it's
Well,
totally.
well, it's totally contradictory. Now, the deal is she's either going to have to say her brother shot her or her boyfriend shot her. If neither one of them, if they're the only two that were there, the three of you,
3 of us just.
okay, there are 3 people there. She didn't have a gun. She gets shot. One of the other of them had a gun. And whether they intentionally shot her or not, I don't know. But now,
The facts are, Judge, that she initially said that Gary shot her. Then later, she reiterated that to the officers in a recording statement in detail. Now, somewhat later from that, she basically has thrown her brother under the bus.
Sir, I didn't have nowhere to go.
don't you
and my
say anything
family-
else till you're called on again.
Huh?
Don't you say anything else till you're called on again. You understand?
Yes, sir, I'm sorry.
Judge, another factual part of this case, my understanding, I've not seen the discovery, my understanding is that her brother left the scene.
Well, you'll get an opportunity, you'll get an opportunity in a minute. I'm gonna let you just as soon as he finishes, okay? You have anything else, Mr. Hunley?
I would like to play that statement. Or at
I'm
least-
not interested in hearing the statement because I know that what she says is contradictory to what she said now, completely contradictory to what she said now. She admits it's contradictory to what she said now. And I don't know whether she was lying then or lying now, but she's a liar, one way or the other.
Let me ask this, isn't it true that after you were shot, that Gary attempted to give you some medical attention or to attempt to stop the bleeding?
Yes.
And didn't he tell you that you would have to lie for him because he would end up in jail? And if that happened, he knew people that would take care of you and your family.
No, that is not correct. He did try to put a tourniquet on me, but no.
And at the very end, when you questioned Hall about that night, and what he asked him, what had you done with the gun that he shot me with? And he said, no gun, no case. Did he say that?
No, sir.
No gun, no case.
No, sir. No. I don't ever remember having that much conversation with Shannon after he
You
had.
called him Shannon. Is that the same person as Gary?
I'm sorry.
Okay. Thought we had a 4th person that was there.
Yeah, are you?
That we could blame the shooting on. Okay, do you have anything you want to inquire of her? Okay, you can go back in the crowd back there. Okay, now, Mr. Hunley, you want to come up here and make an argument about the bond?
I'm not. I think the bond is a minimum. This lady was shot. The defendant was a prior felon. No, there's no question. As you said, there was only 3 people there. Somebody shot her.
Yeah, well, here's the thing.
The injuries that she received were serious. She had multiple operations on that arm.
Yeah, here's the thing, Mr. Hunley. I've set a $50,000 cash bond because of the seriousness of these allegations. He hasn't been able to make the cash bond. Mr. Bell says that the statute says that on a cash bond situation, that a person should be able to post twice the property on it or securities that are liquid, that are worth 50,000.
When an accused makes a statement, you've got to lie for me, or I know somebody.
She
that will
made
take
that,
care of you.
she made that statement, you say, and she denies that she made the statement. You probably got it recorded, that you have it recorded. So it puts me in a very difficult situation. there's some people that you cannot protect from themselves. She says that she's not intimidated or anything. So I'm going to leave the bond the way it is. And if you get somebody to make $100,000 property bond, but here's the thing about it. I want an ankle bracelet on him and I want him to stay away from the victim. You understand? You're not to be around the victim, in and around the victim, anywhere, and an ankle bracelet on him. And well, that's not my deal. That's the deal downstairs. Okay. And they have to go through the process and he'll have to have an ankle bracelet on. And he's also on the curfew. Where's he going to be staying? What house? Whose house? I don't know what. Okay, to his residence is, who are you, ma'am? His mother. Does he live with you? Does he live with you? Okay, so he'll stay at his house. He's under a curfew except the church, work, or the doctor. Okay, he's got an ankle bracelet and $100,000 property bond. That's the rule.
Well, we need to do an order to you, Judge.
That'd be good. Can we do amended bond order? We just do an amended bond order here, okay? Okay, is there anything else?
No, sir.
Okay, thank you, Barron County, for allowing that, okay?
Thank you, Your Honor.
Okay, let's go off the record. Okay, that's it, correct?
I got that guy.
We have Mr. Kimball on that Muse case, Judge.
Where's Mr. Muse? We just let Barron County go.
We're just gonna schedule a hearing.
What I'm proposing, Judge, on the Muse case, I would like to have a hearing on this. I would like to have it quickly as the court can allow us to do it.
Well, how about
Maybe
this?
his attorney can be present for that.
How about this afternoon?
That's a good plan.
You got the attorney on there? They're gonna love us at Barron County. We're gonna call over and get them on again. You gonna have to go over and buy them lunch or something over there, Mr. Hunt.
The jailer just had to walk in the door.
Well, good. Glad to have you. We'll keep you hostage over here. You need to see me or need to see some of these people? Sure.
But I'm headed to my office now, so that will be fine.
Well, with the jailer, what do you got, Mr. Jailer?
Obviously, certified letter is one, I'm supposed to be here.
What's that about?
Lawsuit on this.
Do what?
There's a lawsuit on this.
Oh, is that, Mr. Whitledge? Or not Mr. Whitledge, Mr.
Go ahead and hand it to her.
I know what it is already. Mr. Schultz, is it on here? That got moved to Cumberland County next week, Thursday at 1:00. Sorry.
What we did on him.
And you may want to check because it's been a lawsuit filed in a habeas corpus,
Yeah, really. Well, he's,
but he's been relieved.
yeah, he's, did he make the bond?
I don't know if
before?
he's made the bond yet. He did previously.
Here's what we did. I gave him a new trial and sent it back to Cumberland County. So this
To the
writ of
district court.
habeas corpus,
This is a civil lawsuit.
I know it's a writ of habeas corpus.
Yeah, but it's not in what we did this morning.
Yeah. Relating to 21M105. So I don't know.
Just had to be here at 1:00, sir, so I'm gonna be present for you.
You're here. So I don't,
It's, as of now, it's on the docket next Thursday in Cumberland County.
you
at
moved that
1:00.
habeas corpus too
This is all that's on the habeas corpus.
for here?
Yes, she
Okay,
couldn't be
well,
here this afternoon. Ms.
okay.
Shipley couldn't, so she requested it be heard in Cumberland
The
County.
habeas corpus?
Yes.
Okay, so they moved that to Cumberland County next week. So what you need to do is just get a hold of your lawyer, the Jailers Association, whatever. That's not gonna matter because he's gonna be moved back over on this misdemeanor. See, and back in front of Judge Christie to set a bond. He had a bond in district court that I guess he met. He was out on bond, so he's just gonna go over it. He'll be out of jail probably today. As long as when he makes the bond over there. Did we send an order over there, Megan?
She brought you.
Yeah, there was an order. Yeah.
So
Yeah, or-
so do I need to report to Cumberland County next week or?
Why don't you just check, what day was that?
Thursday.
Check on Monday or Tuesday, okay?
I called Keiko and Keiko said that they didn't figure it was gonna get anywhere past today, that they wasn't sending anybody for me just
I
to
think
make them
that's
approve
good.
it's
I
not.
think
So,
that's good judgment there.
so,
Okay. You just call over to our office on Monday or Tuesday. Just
yes, sir.
Double check it. Okay?
Thank you, sir. I
We're good,
appreciate
yeah.
it. Thank you for
Yeah,
seeing me.
we have somebody that we wanted to hear over at his place. We done had your place on the phone twice today and they didn't.
Anything we can do to
they didn't help. Who is, what'd that lawyer say there?
Right now, Mr. Campbell, it's Terry Wayne Hughes is the defendant. We had him on for a motion to revoke, and Mr. Campbell couldn't be present today for it.
Okay, Mr. Kimball, we're gonna come back in here. What time can you get to your office where you can get on Zoom?
I'm about 2 minutes from my office. I'm in my vehicle now, but I can either call you back on my office phone in a couple of minutes.
I don't want to call, I want to get you on Zoom. You know how to use Zoom?
Yes, sir. If I get back to my office, I can probably access Zoom where we can do it that way if.
Okay, we'll need to send you need to send you a Zoom address, won't you, Megan?
Can I give you my Zoom link and then I can text you or call you back when I get back to the office?
Give us your email.
I've got his email. I will just email him.
Okay, we've got your email and we're gonna email you an invitation.
All right, and that, now the one I'll need will be the plkimball@gmail.com. If you can do it to that, then I'll accept it as soon as I get back then.
Okay, well, we'll schedule that for 15 minutes from now.
All right, I'll be there by then.
Okay, and what we'll need to do is call the jail and have him, the client back on in 15 minutes.
Have a big shoe, Judge.
Sure, have a great day.
Thank you, sir.
It's
I
good
appreciate
seeing you, man. Thank you for all the help you give us.
No problem.
We appreciate it.
Could you just let him know? Terry Hughes.
In like 15 minutes from now. Okay, thank you. Oh.
Yeah.
She gave out. She said, no, and I'm thinking. And we're like, "Is this one on Gmail, but it's address? Do you have a different one? I have is on a Gmail."
I'll text him real quick and see. I feel like it was give something pkimball@gmail.com.
That's what I thought, but when I put it in, I have it as PKD.
Text it to me.
We're gonna go
I think I don't have PL Kimball.
Yeah, okay. I wasn't paying that close attention whenever he said, I knew something Kimball@gmail.
He's called back.
Okay, let's come to order, go on the record. Where's my document? Where's this fill on there at? Gary Hall. There he is down there. Okay, this is Commonwealth versus Terry Muse, which it is 21 CR 0015 and 23 CR 0046. Mr. Philip Kimball is on the line now. Mr. Kimball, will you?
I am here, Your Honor.
Will you turn your camera on?
I will try.
That's all. There you go. There you go. We see you.
Got me? All
You
right.
see your client on here. We previously arraigned Mr. Muse, and I allowed the public defender's office to stand in. Mr. Muse did not make any statements, and he reserved any pretrial motions. We set a conference up for August the 4th, a negotiation day for August the 4th. You can contact the Commonwealth Attorney's Office about that. And the next rule day in court of appearance will be August the 17th. And there is a motion here to revoke probation on Mr. Muse. Mr. Hunley, would you like to be heard?
Anderson is going to handle this end of it, Your Honor.
Okay.
We'd like to call, our first witness will be Gregory King. He's on Zoom.
Okay, Mr. King, would you undo your microphone? Looks like your microphone's off there. Would you raise your right hand, please, Mr. King? You swear the testimony you're about to give is the truth, the whole truth, nothing but the truth.
I do.
Okay. You may proceed to inquire. Would you identify yourself, Mr. King, and with whom you're employed?
Officer Gregory King, with probation and parole in Lexington, Kentucky.
Okay.
Mr. King, has Terry Muse been under your supervision?
Yes, ma'am.
And when did that supervision begin?
I started supervising him in District 9 on June the 1st of 2022 via a transfer from the district down there in Monroe.
And since his supervision under you, has he had any violations?
So the only violation would be he verbally said that he was out of county to sign paperwork on a house in Somerset. And then once he was indicted on the new felony charges, there was a violation for new felony charges.
And do you know, as part of the conditions of his probation, could he have any contact with the victim of the case that you were supervising him under?
So the court order I have for that case is no violent contact.
Did you ever receive any type of report from Pulaski County regarding any violent contact between Mr. Muse and the victim?
So there was, I actually received on June the 5th, a email from the Commonwealth Attorney's Office down there asking about an alleged assault in Pulaski County that happened on that Sunday night. I did not see anything as far as new charges or anything like that. And then we corresponded back and forth, and I went through KY Ops, which is a system that probation and parole, as well as other law enforcement agencies in the state, can see, and I saw that there was a JC3 report regarding Mr. Muse and Miss Wheeler that was filed, I believe, on June the 4th.
And Miss Wheeler, it'd be Julie Wheeler. Would she be the victim in the case that you're supervising him under?
Yes.
And do you know what was the violent contact between that you received in that report from Pulaski County?
Okay. Yeah. So I actually have the SSR pulled up here. And the JC3 report says on 6/4/2023, I responded to Victory Christian Church, and the I would be Deputy Preston Pittman. Victory Christian Church at 1156 Oak Hill Road, Somerset, KY 42503, in reference to a domestic violence victim that had fled from the location of the incident in order to get assistance for law enforcement from the reported abuser. And it states, upon arriving on scene with officers from the Somerset Police Department who were currently out with the victim, Miss Julie Wheeler, when speaking with the victim, she advised that her fiance, Mr. Terry Muse, had grabbed her by the hair on the back of her head and jerked her in an aggressive manner and then struck her in the face with a Taco Bell bag filled with trash. And when coming back with the bag, had also struck the juvenile daughter, initials of MM, date of birth 11/19/2021, in the head. She then went on to advise that he had also grabbed a hold of her by the throat, pinning her against the wall, preventing her from getting away from him. I asked Miss Wheeler if she had felt her normal breathing was impeded while he had his hand on her throat, where she then advised that it did not, and that it was to keep her against the wall. Miss Wheeler then advised us that Mr. Muse has been on probation for previously domestic violence charges, where he was reportedly convicted of strangulation in another county, where she was also the victim in that incident as well. Miss Wheeler had refused EMS on scene and advised she did not need safe passage due to her using her own vehicle to transport her and the children back to her parents' residence, where they also had friends meeting her along the way to check on them as well.
And you stated that one of his other violations was where he has moved to Somerset without reporting his new address to you.
So I don't know if he's officially moved in yet. He did advise me when he reported that he had bought a house down there and was thus out of Fayette County to sign the paperwork for the house, is what he advised me.
Okay. I don't have any other questions of this witness.
Okay, will you have any questions for the witness?
Your Honor. May I ask, Your Honor?
So Mr. Kimball, do you have any questions for the witness?
Yes, Your Honor. Mr. King, how long had you been supervising Terry Muse?
So I've supervised him when this incident came about approximately a year.
Okay. During the course of that time, did he always report as he was required to do?
He did.
Did you find him to be compliant with your restrictions or directions for reporting?
Yes.
Was he employed?
Yes.
Do you know where he was employed?
He provided pay stubs that he was employed with McLean, which is in Nicholasville, Kentucky, just in a county south of us, driving a truck, basically in central Kentucky.
Okay. Did he have any, during that time prior to the incidents that Ms. Anderson described, did he have any violations or issues that would have been necessary to bring before the court or to require hearing from your standpoint?
No, sir.
As you sit here today, is he in violation of any of the restrictions that you placed on him?
He, as of today, is still in violation on his probation based on the new felony charges. Yes.
Okay, but based on that, during the year prior to that, did he have any violations?
No.
Do you know if Mr. Muse had military experience?
Yes.
Do you know whether or not he received the Purple Heart during the time he was in the military?
I have no knowledge of that.
Do you know where he's living, or where the house was he bought?
The address provided that he was buying the house at is 120 Summer Shade Drive, and Summer and Shade are split up. It's not one word. Somerset, Kentucky.
All right. Are you familiar with Veterans Court?
I've heard of Veterans Court. We don't really deal with it on our end of supervision, but Veterans Court is a thing, yes.
Okay. For the year that you were his probation and parole officer, did you find him to be supervisable?
Yeah, like I said, he was very compliant.
Okay. Your Honor, that's all my questions.
Gordon Anderson, do you have anything else?
It's just one question, Your Honor. Mr. King, would the contact that Mr. Muse had with Miss Wheeler in Somerset, Kentucky, would that have also been a violation of his probation?
So the alleged violent contact?
Yes.
Yeah, so any violent contact of any nature would be a violation, yes.
No other questions of this witness?
May the witness be excused?
Yes, Your Honor.
Yes, sir.
You may be excused, officer. Thank you. You'll call your next witness.
Yes, I called Julie Wheeler.
Stand close to the microphone there. If you can, you raise your right hand. Swear the testimony you're about to give is the truth, the whole truth, nothing but the truth. State your name.
Julie Wheeler.
You have to speak up. You're outside voice. Okay, you're safe here. Go ahead and speak up.
Julie Wheeler.
Okay, go ahead.
And Julie, were you the victim of Mr. Muse's first case here,
You're gonna have to speak up too.
sorry, the 21 CR 115?
Yes.
And are you aware that you could have contact with Mr. Muse when he went on probation?
He had told me about the paperwork and told me that it said it was a non-violent and not a no contact.
Okay. And since he's been on probation, have you had contact with Mr. Muse?
Yes.
And has there been any incidents of where it's been violent?
Yes.
Okay. And when did that occur?
A few times before the time that I called Somerset Law, but on June 4th, there was a violent contact.
Tell the judge what happened then. Speak up.
Okay. I went to the house on June 4th. He asked me to come there, bring him some food. We went to Arby's and then I went there. We got into like kind of an argument, something that shouldn't have been escalated very far. Then as we were in the basement and I was going to leave, he grabbed me with his left hand, the back of my head, my hair, and jerked me backwards. And then he had the Taco Bell bag in the right hand and it was full of trash. I had our daughter on my hip and he swung it and he hit me in the face with it. And then whenever he come back, she went to screaming. He hit her with the bag as he come back away from my face with it. He dropped the bag and then he got hold of me with his hand around my throat and I went back into the corner, like there's a bathroom and a bedroom and there's a corner there, and went there and he had it's like a scraper like you use for paint, but it has like a blade and you can remove it. And he said that he was gonna slit my throat. And I said, I'm just gonna leave and let you calm down. So then I left and called the law.
And did they issue a report after you called them?
They talked to me and then I went to the county attorney's office in Somerset and I wrote everything down, signed it and everything. And they informed me that it would probably just be a misdemeanor because it was just an assault and it would probably be dropped anyway. So then nothing came of it.
So what happened after that day?
After that day, he found out about that I had called the law.
So then on June 9th, he called me multiple times asking me to make it as a false report. And he then threatened to kill me if he went back.
And where were you when these phone calls came in?
I was in Tonkinson at my house, sitting on the couch.
And did you record any of these phone conversations?
Yes.
And did you also take pictures of the timestamp on whenever these calls?
Yes.
Your Honor, may I show her, approach her and show these? Do these, you recognize these photographs at all?
Yes, this is stuff from the phone.
Is your front, and what day and time did he make these phone calls?
He made the one where he threatened to kill me was at 2:33 when I took the.
And what day?
It was on June 9th, 2023 at 2:33 p.m. One of the phone calls where he asked me to change it to a false report was on June 9th, 2023 at 9:29 a.m. And then the other one where he was asking me to make it a false report was on June 9th of 2023 at 9:26 a.m.
And you said you did record these phone calls?
Yes.
Your Honor, at this time, we want to play the phone calls.
Okay. What about the paper you want to
I
introduce?
do want to enter it into evidence, Your Honor.
Exhibit number 1 is Commonwealth's exhibit number 1 to this hearing. Let it be marked without objection.
And you said some things that wasn't true because you're not under oath. You're not going to get in trouble. You was mad and you said some things that wasn't true because you thought I was cheating on you. I told him the only thing that I've done was jerk my phone away from you. I told him I never hit you, never nothing. You're going to have to do this. You don't have a choice or I'm going to prison. Jesse Stockton gets a hold of this. The Monroe County Sheriff's Department gets a hold of this. I got a warrant for my arrest. Do you understand that?
Yes.
Why, Julie? I'm doing everything I can for you. I bought us a goddamn house. Why?
Why did you hit me? Why was you?
I'm sorry, but you kept on. You kept on. You kept on. I promise you, I will never lay my hands on you again. You have got to fix this. I don't have another chance. I'm going to prison if you don't tell them you was upset, you said some things that wasn't true. Please, I am begging you.
Do we need to play it again, Your Honor?
No, go ahead. Is that all of it?
No, we've got 2 more phone calls.
Okay, continue.
You have got to call the police department and you have got to tell them that you was upset because you thought I was cheating on you, that I never laid my hands on you. I never hit you. I never hit Maddie. I never hit Maddie. I would never in a million years hit that little girl.
She was in my arms when you hit me and it hit her.
No, I did not.
That's why she went to screaming.
Okay, I'm done. I'm going to stop.
You don't talk to people like that.
I promise you this, if I go back to prison because of you, your death is gonna be on my fingers one day. I promise you that.
Stop saying that.
Oh, it's the goddamn God's honest truth. If I go back to prison because of you, I'm gonna be the one to take you out of this earth. I'm getting ready to lose everything that I have worked my ass off for. I'm getting ready to lose my daughter and everything because of you.
You don't kill anybody. That's not right.
Well, you'll find out, bitch. So take that to the police.
You need to speak up.
Did you recognize the voice on those phone calls?
Yes.
And who was that?
Terry Muse.
And those phone calls were made after the incident in Somerset.
Yes.
And did you, after you received those phone calls, what steps did you take after that?
I called my mother and then we contacted Jesse Stockton. I contacted my mother. We contacted Jesse Stockton.
And there's been no charges filed against Mr. Muse because of these phone calls?
Yes.
Okay. And since that day, have you received any more phone calls from Mr. Muse?
Yes, he calls a lot. He called while I was sitting in here.
Has he tried to call?
Wait, let her say that clearly.
Yes, he calls a lot. He called while I was sitting in here.
Today?
Yes.
How many times did he try to call you today?
He's called 3 times and tried to video chat 3 times.
I have no other questions of this victim.
Mr. Kimball, you have any questions?
Not at this time, Your Honor.
You have any other witnesses?
No, Your Honor. Oh, before, I would just ask to admit the phone calls and
We will
evidence.
admit the recording of the phone call. It's on the record now, and you can admit a hard copy if you'd like, but I think we picked it up also. Yeah, the witness may be excused. Okay, now, do you have any other witnesses?
No other witnesses, Your Honor.
Okay, Mr. Kimball, would you like to call a witness?
No, sir. I think Ms. Anderson's probably explained to you what my situation's been today, and I'm sorry I wasn't there for court. I just found out my 98-year-old mother has COVID, so it's been a very difficult day for me already, and I apologize to the court, but I just...
I understand we all have things, but you're here now.
I am.
Okay, and we appreciate you. You have any witnesses you'd like to call?
No, sir, I don't think I need to put Terry on at this point. And
this is the arraignment that we had, I guess, was on, was it on 46 today? Yeah, it's on 2023 CR 0046, which was the incident that was described today by the witness. Do you have any arguments you'd like to make on the revocation, Mr. Kimball?
I do, Your Honor. I researched this pretty extensively, and I've discussed it with Mr. Stockton. Terry came to me very broken from a variety of things, but primarily from his injuries that he received in combat, which resulted in him receiving the Purple Heart. I have explored at some length the Veterans Court, which is set out very clearly. As I researched it, I've discussed it with Mr. Stockton, and I am asking the court to consider that as an alternative to just sending him to prison. And I know you have difficult decisions to make, and this is certainly one of them. But I think the Veterans Court, as I understand it, is set up for veterans that have been injured in combat and that are trying to get readjusted into society. So as you consider how to resolve this, I would ask the court to allow Mr. Stockton and me, or Ms. Anderson, whoever it is, to explore that as an option rather than just sending him to prison. He was employed. He can earn probably $1,500 a week at his job for McLean. And I think he fits the description very clearly of what the Veterans Court is all set up for. So I would ask the court, as you consider your options, that you also look into the Veterans Court option, because I believe that really fits Mr. Muse's situation. Obviously, a condition of any of this would have to be no contact with the victim whatsoever. And I would simply ask the court to consider those options as you decide what's just in this situation.
Ms. Gordon Anderson.
Your Honor, we ask that you revoke Mr. Muse. I think it's very clear from that phone call that if he is out, he is going to kill the victim. So I would oppose anything other than just prison. That's what we want.
Well, I appreciate Mr. Muse's service and the sacrifice he made for his country. I do not think that he's capable of being supervised. I mean, when we're sitting here in court after an indictment has been returned on him about these allegations here, and he's still calling the victim in violation of the court-ordered no contact on his previous felony, he's still calling her, and I hear this motion where he's going to cut her throat, and that'll be the last thing she hears. That goes beyond the pale. And so I'm going to revoke his probation today, and he still has this other charge over here. I cannot take the chance that this woman will suffer death. I've never heard a more direct or violent threat made against anybody in my life than I've heard here. And I've been practicing law a long time and had every kind of case in the world. Mr. Muse is dangerous. And I don't know what the origins of those are. I don't know whether he was dangerous before he went in the military or something happened in the military, but this woman does not deserve, with her child on her hip, to be threatened with her death and called even here while she was in court. If this court cannot protect somebody on a stay away order on a felony charge like this, we might as well close shop. And I'm not ready to close shop. So that concludes this hearing. I'll enter order revoking, and we'll deal with the other case that he has coming. Thank you, Barron County Jail, for allowing us to hear this. Okay, now let's pick up the 1 o'clock docket. I hope your mother's better, Mr. Kimball. I know it's very serious.
I appreciate your indulgence. Situation.
Yeah.
May I leave the Zoom call now?
Absolutely. Thank you.
Thank
you. Okay. We're going to take a short break. Okay, that was it. We're ready to go. Guess we're on the child support docket. Child support docket. Okay, arms versus arms.
You swear Ms. Staples in, please.
Swear the testimony you're about to give is the truth, whole truth, nothing but truth.
Yes. State your name for the record, please.
Monroe Staples.
And you're familiar with the case Commonwealth of Kentucky versus Edwin Arms?
You have to speak up a little bit. I'm sorry.
I'm sorry. I don't know what. Monroe Circuit Court, case number 17 CI 104.
Yes.
And Mr. Arms was before this court, and a contempt order was entered on April 20th, 2023. Is that correct?
Yes.
Has Mr. Arms taken any steps to purge himself of that contempt?
No.
Judge, we had asked for an arrest.
Bird versus Bird.
Judge, this is our motion to modify child support, and based on the Kentucky child support guidelines, it decreases from $529 per month to $289.10 per month. So it meets the requirements for a modification.
Yeah.
Modification in it later.
Fox versus Fox.
Continue to August 17th, please, Your Honor.
No friend. Gallup versus Gallup.
Continue to August 17th, please.
Modiano versus Gomez.
Judge, this is almost as good as a dismissal. We're changing the venue to Barron County. They've all moved to Barron.
Absolutely right. Greener pastures. Heston versus Heston.
Continue to August 17th. Honor.
Hudson versus Hudson.
Continue to August 17th, please, Your Honor.
Jimenez versus Jimenez.
Continue to August 17th, please.
Moore versus Teach Out.
Judge, this is our motion to establish child support and medical support. Mr. Teach Out, I think this was, we didn't initiate this case, so he was already before the court. They just asked for our services after the case was. We just based it on minimum wage for both parties.
Okay. Good. Good docket. Thank you very much. Okay, we have KFBMIC, also known as Matthew. ASO Matthew Payne versus Billy Rich and others. You take a
Yes,
look.
Your Honor.
Okay, what do we have here?
Plaintiff's Bertram here for Kentucky Farm Bureau. And it's the plaintiff's motion for default judgment as to the defendant Turner. We're still trying to achieve service on the defendant Billy Rich.
Okay, I reviewed that and it appears to be in order. We'll enter that order, okay?
Thank you, Judge.
You.
This is the only case we had on for today, Judge. If there's nothing else that we can help the court with, may we be excused?
Have a great day. Good to
Thank you,
see
Judge.
South Central Bank versus Jennifer Shirley and others. Hello.
Judge, this is my motion for default judgment, summary judgment, and order of sale in a foreclosure case. Jennifer Shirley and Jimmy Strode were both served and neither one filed an answer. The other three defendants did answer and asserted their delinquent tax liens. They're superior to the claim of South Central Bank. There's no opposition.
Okay. Did they file in the case the tax lien holders or?
Yes.
Yeah. So you're not asking for just an order of sale, and then it'll be determined what they're entitled to later, what their judgment's been reduced?
Judge, it's my understanding that Monroe County's first.
I'm not talking about the order. Have these tax liens been bought by other people?
Oh, yes, sir. I'm sorry.
Yeah, and what I'm saying is usually it would appear to me that their lien would have to be reduced to a specific amount at some juncture. You could sell it subject to the lien, I guess, but wouldn't that damage They intervened in the case and pled what they're entitled to?
They asserted that in their answer, Judge, and of course, the interest accrued thereafter. As far as exact amount today,
Well, the judgment would have to include their amounts, wouldn't it? At some, don't their liens have to be reduced to judgment? Is what I'm asking. I'm not saying it'll affect the validity of the lien, but at some juncture.
yes, I will, Judge, and I can contact them and tender a supplemental.
Well, why don't you do that? So we'll have, because when the master commissioner gets it, at some juncture, there'll have to be a judgment, a determination for what amount they get before you get your mortgage out.
I will obtain that information.
Yeah, if you'd like to take this fly with you when you go here that's attacking me, it's vicious.
I guess he followed me from over that corner.
Yeah, I don't know. Where'd you come from today?
Bowling Green.
That's what happened.
I said, do it every time.
Yeah, okay, thank you very much.
Okay, and I'll file a motion for supplemental judgment then with that
Okay.
information.
Charles Strode versus Strode Funeral Home. Hello. Hey, y'all.
We appreciate your time on this.
That's good. I spent a lot of time on it last night.
I'm sure the court's been familiar with our position on the matter, that it's a valid non-testamentary transfer on death. And, our position is consistent with Kentucky case law. But
You say it is?
we do say that it is.
Well, I've looked at this thing and, previously I noticed your motion that I said, if this is that little document I have here, I've noticed it. Is that a contractual agreement or what is that?
KRS 391.
Now, what is it? What are you saying this document is here?
That would be a written provision for a non-probate transfer on death. So if there's a pre-existing contractual agreement, the parties to a contractual agreement like that can dictate the transfer.
Well, let me ask you about this. Did Brandy Harwood have any loan that was owed to Strode Funeral Home Inc.?
My understanding is that there was a loan outstanding that was owed by the funeral home.
No.
At the time. that
No,
the
I'm asking, the funeral home owed Brandy Harwood some money? See, this agreement.
Oh, yes. I
This
understand, Your
agreement
Honor.
says that if Brandy Harwood dies, that the Strode Funeral Home was to pay any loan that was owed to her to Charles Strode. If Charles Strode dies, that Strode Funeral Home was to pay anything that was owed to him, which is, it's agreed with everybody, was almost $100,000 to her.
That's correct.
Was there, had she made any loan to Strode Funeral Home?
I'd be happy to supplement the record on that, Your Honor, but I do not exactly recall.
Well,
if she did
I've
owe
looked
a
at the
debt.
record, everything is in there. Now, I don't believe that this is a valid will.
It's not.
Well,
We
I'm glad
agree
you
with
agree with me.
Yes.
I agree with that too, Judge.
Well, let me finish. Okay. It might have been an attempt because it talks about her leaving stuff to him, which is kind of will sort of language. But I don't think it's a valid contractual agreement either, because there wasn't anything she had to do.